For judgment, item 1.
Fill out.
Item 2.
It is partly allowed and the sentence is modified.
Item 3.
Is the appeal is allowed and the appeal is good.
Item 4.
Appeal is partly allowed.
Item 5.
It's partly allowed.
Item 6.
Partly allowed.
Item 7.
Partly.
Item 8.
Criminal appeal is allowed. Obvious.
Item 9.
It's partly allowed.
Item 10.
Partly allowed. Partly allowed.
Item 11.
Partly allowed.
Item 12.
It's partly allowed.
Item 13.
Partly allowed.
14.
Partly allowed.
15.
Partly allowed.
16.
Partly allowed.
17.
Partly allowed.
18.
Dismiss. Yes. Definitely. But we should put some other than. Yes.
Nineteen, Your Lordship. May please, Your Lordship.
One
19
line.
is 3.
Who is their lawyer?
My Lord, 19, I am appearing through VC, Your Lordship.
Tell them to call the lawyer so that we'll hear it. The old couple is unnecessary. You are ready? We'll hear it. Just will run through the
Yes.
list thereafter. I'll hear. Tell.
Reports
Yes. Yes. Reports, huh? Item 20 onwards. Order the circle.
Mention
19. Yes, item 19.
May it please, Your Lordship. Item 19, my Lord, it is a 498A and 30P conviction matter, my Lord. Your Lordship may kindly fix it to 2 p.m. Mr. Mahapatra, Senior Counsel, will argue this matter today only.
Okay, 2 p.m. Tell these couples to relax.
Grateful, my Lord.
Yes. Yes. Item 20.
Item 20.
Copy of the proceeding of trial court is not here. What is he asking for? Okay. Okay, pass over. We'll see. Yes.
21,
Notice issued to sold OP written answer with a postal endorsement address he left without instruction and sent to the sender. So notice kept service is not complete. Service is not complete. First steps should be taken. Complete. Yes. First steps or service. Yes. Next. 22.
Except the report of Baya and Ananda.
22.
Yes.
What happened?
Two of the appellants have received, but under
No, 22. How many?
three, my lord. There are three.
Three
cases.
separate.
Yes.
He is Baya.
Baya.
46 of 1994. ये item 22 there. There are 3 appeals. 46 of 1994 dead. Stand sebated. তারপরে আনন্দ বিষয় 71 of 94 আনন্দ died. ঠিক আছে. What about the other one? Also, okay. 86 of 94 रे ABT. नहीं এটা তো ABT না 86 রে जो report has report is still awaiting. Yes, 2 o'clock somebody mentioned.
Yes, sir.
2 o'clock, okay, no problem.
I have some other matter in some other corner benches in the
Lordship.
first hour. If I will held up, cannot attend. At 2 p.m. I will start.
Lordship,
my argument.
yes, that's what somebody mentioned for you. Somebody mentioned for you, 2 o'clock I'll take it up.
Yes, sir.
No problem. I'll fix it.
Lordship,
Your matter will be taken up today.
Lordship, items 72. Lordship,
I have started the list.
Okay.
I have started the list. I know that. I'll take it up today. Yes. Yes. 23, 23, no report.
Yes, my lordship.
23, who is appearing? Today you are appearing in all the matters?
No, my lordship. I am up to 41.
The other prosecutors have changed the court time or what? Why are not there? 23, who is there? I don't know. So 23, so 24, what is the position? There are 2 appeals.
Yes, my lordship.
What happened to this? Mr. Mahanti, you change the court time.
Extremely sorry, Lordship.
Come in time. But he is alive in 28.
Yes.
24. 23, are you appearing?
No, my lordship. I am appearing up to 41. I have given all the.
23 report is on control. Somebody is there. And the next 20, 25. 25, 1 item only. 24, there are 2. The report I have there. 25,
25 report is not ready.
residing. The exact present is not available. Residing. 25, 25. Yes.
26,
26. They are not into what is this report is? 154. Filed in the High Court of Orissa. In reply, both the brothers stated that the above noted case disposed of, and they are not interested to proceed with the
Yes.
criminal appeal. What is this then?
They have inquired my lordship. The IS local IS have gone there and they are saying that they are not interested.
They are convicted or not interested means what? You are appearing.
Man,
What is the matter? They are still alive.
section 31X, my lord.
Huh?
11 months conviction. 11 months conviction, my lord.
Yes.
And they were custody for 20 days.
20 days.
My lord.
Then 20 days is all right, but whether it is a case of acquittal or not.
And
there is-
the informant was, my instruction is the informant was died on,
informant might have died.
my lord.
That is neither here nor there.
Dead may be fixed.
But they are saying that we are not interested.
No, no,
They
sir.
are
that-
convicted.
They are the,
Report ready for hearing for the 25, 26, 26. Ready for hearing? Okay. Yes. List it up.
27,
Short date the not because 25, 26. No, these are 95 matters.
my lord, sir,
Not
I am
yet,
ready.
yes.
But they dead.
27,
Not received, my lord.
27 not received. Okay, not received. 28,
28,
28. Sole appellant died.
Yes, my lordship. 27,
Hmm.
28.
Died on 23/7/12. 2012. Huh? Awaited in the absence of. Okay. 2022. Yes. Next. 29.
29 to 48, 29 to 48.
Now who is appearing? 29 to 48. No report.
No, my lordship.
29 to 48.
20.
41.
41.
Why there is no report? Because see the orders are
My
29
lordship
to.
is already intimate. They will, my lordship kindly pass over. I have already intimate them. And I asked them to provide me report 10 o'clock.
Okay, pass out. Just
Yes,
wherever report
yes.
comes and you see. 49. The 49.
48 है, 49 का
49 টা আছে 49.
48 है.
আছে নি রকম 49 টা করবে.
Yes, yes.
He asked,
Lordship, except 32,
হ্যাঁ,
there is no report.
no report.
32, but 33 there is report.
Okay.
34 is report.
Give me 33. 33 report. What is the report?
33 report, expired.
Expired.
33 Lordship is sole appellant, 33 expired.
33 expired. Give the report. Huh? Awaited. Lady. Awaited. 33 died. Huh? 33 awaited. Huh? 34
Alive.
alive. Huh?
Out of 3 appellants,
Huh?
out of 2 appellants, number 2 died.
Appellant number 2.
Died.
34.
34. Appellant number 2 died. Stands awaited for appellant number 2 and the other. ठीक है? ठीक है. 35.
35 only no report, Your Lordship.
No report. Okay. 36.
36 no report.
Okay. 37.
37 report available, Your Lordship. Out of 3 appellants, appellant number 1 died.
1 died. Look here. 37 report is there. Yeah. 38.
38 Your Lordship, sole appellant expired. Your Lordship. 38.
38 sole appellant Gajendra Prasad Maharana died. Awaited. ठीक है? Okay. Yes. 39.
39 Your Lordship, no report.
40.
40 also no report, Your Lordship, one more opportunity. 41 Your Lordship, report available, sole appellant expired. Your Lordship.
Expired. 41. Sole appellant Satyabrata Mahanto died. Huh?
Yeah.
Awaited. Yes. 42.
42 Your Lordship, report available, sole appellant expired.
42. Ramachandra Pradhan sole appellant
Written report from the issued by the sub-punch of that local.
died. Died. Huh? Awaited. Yes. 43.
43 report available, alive. Your Lordship.
Alive. Okay. Ready. Huh? Ready for hearing. 44.
34 Your Lordship, reports available, report Your Lordship available, out of 3 appellants, appellant number 2 died.
43. Huh? 43 you are talking about.
44.
44. 44 the 3 appellant also did.
43 alive ना.
Yes, Your Lordship.
43 alive छोड़ो. Ready for hearing लगा. ठीक है? And 44 1 died. Stands awaited. Whoever
Number 2 died.
died stands awaited is the other. 44. How many appellants are there? 44. 2 Jogi Das died. ठीक है?
Given the report and the.
Yes. 45.
also one more opportunity.
Okay. 46,
46 also no.
no report. Don't get hurried. If the reports are there or not, don't.
In this matter. 47 also report available.
What is the report? What is the report?
47.
Alive. देखो, alive ना? छोड़ दे, ठीक है. 48,
One more percentage.
okay. 49 तो आ गया था 49 आ गया. Yes. 50,
There is no report, one more person.
no, 49 report has come. She had given and yes. For 50,
50 is also, there is no report.
no report. 51,
One also no report.
52,
One more person, there is no report.
okay. 53,
There is no report, one more person.
54,
54 report is there.
yes.
Report will have died, my lord, my instruction.
Died, huh?
Yes, sir. My instruction also died.
No. Emitted, huh?
Yes, sir.
Sole appellant Bistu Chandran Bera, died. Yes. 55,
55 report is
not there?
no.
Okay. 56,
My lordship report is no. Not there, my lord.
okay. No report. 57, got the report? How many appellants
Yes,
are?
sir.
All are alive?
No, no. It's not.
2 appellants. Anybody has died? Who has died?
So,
So we'll be going through the.
When this two apparents are there, of course, the whole report is available. Lordship, appeal number 2 is alive. So far, appeal number 1 is concerned, there is the instructional guide.
No, he says the appellant has already died.
There is a two, Lordship,
two
It is
instructions.
there is two
272.
instructions available. One is issued by the OIC Ambogana police station, with two reports.
Hrudananda has died. Appellant number 1, Hrudananda, has died on 20th of July 2020, 2008. Huh? Evident. What about
Madhu is alive.
Madhu is alive? Madhu is alive. Huh?
आपने वो बात बताया
2 is alive. ठीक है? Yeah, 57. Yes. 58.
58
58. The report is there? No. Somebody else is appearing. Who is appearing?
Wait, my senior is Iba Mahanti, senior.
She should come in time. We can't, till 11 o'clock, we can't wait for them. So once she comes, we'll see. Next. And she will give the report till 68.
63
Till 63, she is appearing.
50 to 70 or also time lines. Just Iba Mahanti is appearing.
74 other.
She can't tell that she can't come at her leisure. We can't wait for her. Yes. Start off.
71
Hearing starts from
71
71.
71
71. We'll see, we'll hear Mr. Ponda's matter. He has been, every time he's waiting. Yes, who is appearing from the other side? Mr. Ponda's matter, IT two. 85.
85, Your Lordship, my respected senior AGA, also Kapat is appearing in this matter also.
Please tell him, come.
I've already intimated to him, Your Lordship, on the ground.
Just wait, let him come with that stuff. Yes.
76.
And
There was basically inside.
26?
76.
so whom judge software kon
Yes, madam.
may I please, ma'am?
26.
It was heard earlier?
No, no. Easy.
Acha. Okay, ECA. Yes, madam. Then I file that.
There is a sole accused, date of offense.
Who is appearing from this side?
Item
76.
76 also Siba Mahanti is appearing in this matter.
See, this is not done, I tell you.
76 also.
This is done. I can't wait for them.
No, it's extremely regretted.
I'll
I'm sorry.
straight away I acute if you are not there recording this. What is this going on? Yes, fine though. I can understand the private lawyer can't come. Prosecutors are fixed for this court. You have to be here in time. Yes. Yes, madam.
My lord, there is a sole accused.
Yes.
Date of offense, my lord, 29/1996.
Yes.
Date of judgment, my lord, 3/8/2001, passed by learned special judge Kurapur, Jaipur.
Yes.
And this case involved offense under section 7 of Essential Commodities Acts, 1955.
Yes.
Under the accused is convicted vigorous imprisonment for 3 months and fined 1,000 in default 15 days, my lord.
Yes. Section 7. What was the violation, madam? What is your name by the way?
Mona Lisa Mohan.
Mona Lisa Mohan. Yes.
My lord, the accused throughout investigation, he was on bail. Also throughout trial, he was on bail. And till now, my lord, he is on bail.
Not undergone any.
No. In some issue summon to the accused, and he was present in court 19/9/1997 by such summon, madam. And court grant bail to the accused 19/9/1997.
Okay. Yes.
My lord, out of 5, 2 material witnesses are independent witness, PW1 and PW4. Are independent witness.
PW1 and PW4.
Yes, my lord.
Yes, independent.
Yes.
Let us read PW.
Yes.
PW1. Read PW1.
PW1, my lord, he says that he knows the accused, who is the proprietor of Srinivas Automobile, and he says that on 29/1996, supply inspector called him and gave him the zima of lubricants with the accused in his presence by preparing zima. Exhibit 1 in the Zibanama and Exhibit 1/1 in his signature on Exhibit 1. In cross-examination, my lord, he says that he does not remember the number of pipa given in Jima of the accused. He was not present at the time of preparation of Jima.
But he didn't support the prosecution.
No, not support,
Not support.
my lord.
He was the seizure witness, not supported.
Yes, my lord. In in cross-examination, my lord, he submits that no.
Letter complete, madam. Huh? Not supported,
Not
seizure
supported.
witness. Yes. Yes. Yes, proceed.
PW4, my lord. Another independent witness.
Okay. Read it.
In PW4 says that the witness does not remember contents in which he happens there at the spot.
Read it. Which part here?
Yes.
The witness
the
found the accused having stored lubricants. and grease in his shop. The witness saw the accused present in this shop at the time of the search. The witness found the article kept for sale with the personal credit. The accused could not produce the license to storage. The witnessed the serial of the article that was signed by the witness in the serial list. The witness identified his signature. What kind of evidence this, just see? His statement is not recorded. Just see, read it. Read it, just read it. PW4. It is not his version. The court writes. Just read it. What kind of recording of this evidence? He doesn't say that I found. The court says the witness found.
If the customer present, the accused could not produce the license of the seller, which totally convicted and this, the witness the seizure of the opposite article and post judgment as witness in the seizure list. The witness identified the signature as result from the key in the seizure list. After the opposite articles are in the GMA of the accused as per the GMA number exhibit 1. Office the witness was witness to the signature as well. After examination of witness, I know the process of the.
This witness appears to be supporting the prosecution, isn't it? But the recording is very. But recording should have been in his voice, not that you ask and record your opinion.
He said that he does not put the number of TIPA. So here they have seized the TIPA minorship. But he is agreed to that season has done and some TIPA has been carried out by that. But how many numbers?
No, he says that he denies that no seizure of the articles was effected and articles were seized given to Jima. And he has para 2 says.
Given in Jima of the accused, he was number of people was given in the Jima of the accused. He was not present at the time of the
Jima number. Then he sees that he was not there. Then thereafter you read it. He denies that.
Was affected and the articles were not given in Jima.
So the seizure is not, he is not completely not supporting. 4 is somehow supporting. Partly supporting. But see the, I don't know whether it is evidence. How will I take it?
PW2 mailer admits that no customer were present at the time of inspection and no sale occurred.
PW?
PW2
Who
mailer.
is he? PW2?
Marketing inspector mailer.
Here also the same thing. The witness says that knows the accused. One of the witness was marketing inspector. On that day, he along with what do you want to point out from PW2?
Says that no customer were present at the time of inspection, madam.
The important thing is seizure. The seizure has to be proved. Yes.
Then another point is that no chemical test was conducted, madam.
Where is that? Where is that?
My lord, in cross examination, point 4, my lord.
Huh?
Second para,
Second para.
yes,
If
PW 2.
read it. He denies the suggestion that the inspector supply is not competent to so and so. No test was conducted in respect of the seizure articles. No,
No test was conducted in respect of the seized articles.
What does it say?
Saying that relevant for the statement, the current counsel for the people for the seized material having not been chemically examined. It cannot be said that the things seized from the accused.
एक मिनट एक मिनट para 4 and judgment which para? Para 10 हाँ ठीक yes 11 okay para 11 what does it say?
Cannot be said that the three things seized from the accused contain desiccating oil or grease. When the things are sealed by the producer company and treated as lubricating oil or grease, there was no necessity of any such chemical examination. The season itself shows that the sealed things by item number 4, 5 both prints that the thing contain lubricant in the accused food and displays the things as a lubricant. It is not open to him to argue that the things not contain a lubricant.
Because it was in that diba sealed diba. Yes. Yes, madam. Who is 3?
He also mistake. PW 3 mallet says that he does not know the neighbors present at the time of inspection mallet. Obviously, and he cannot name the two.
It is whose shop? From where it was seized?
PW 3.
Yes. Hey, what is your what is your story? Prosecution story. Because the PW 2 and 3, both of them are saying that they don't know whose shop was that.
Yes, they have. They come to know that there was a lubricant oil and Breeze was selling without license.
That's right, but in whose shop?
In the grocery shop.
Whose grocery shop?
Neither's
They should know suppose in your shop something is being sold, she cannot be held responsible. You have to say that it is your shop, you are selling it. Then only the case is made out.
That shop.
Whose shop is that? How do you relate this man with the shop?
Owner of the shop. They come. He is the owner of the shop.
Where is the evidence? Show me.
Yes, my lordship.
Where is that evidence? Show me. PW3 rather says the shop in question is situated on the main road of at Similiguda. The witness does not know the neighbor of this. No paper was seized from the possession of the accused, so and so regarding the ownership of the shop. 2 witnesses present at the time of search and seizure. and the witnesses cannot name them or cannot be given their address. The officers, supply department did not purchase anything from the shop. The lubricant oil were kept in the container. The container were sealed. The witness does not remember the container were opened. The so and so, so and so. Some of the tin contain the grease. The witnesses cannot say. The witness denies that nothing was seized of the so and so.
My lord, for the PW 3 admitted in the project examination that no paper was seized from the.
That I read it.
postal
That I
accused.
read it out.
Yes,
That's what I'm asking. Which 5? Yes. Anything else?
No. On my motion, the case of the on 29 itself, the inspector of the supplies, they come to know that he is running the business without license and without any office. For that, they have.
Where from it was seized?
But it was the judgment said in the name and the style of the Srinivas Automobile. So when they go for the investigation and they come to know that he was.
But Srinivas Automobile is owned by this Kameshwaran,
Yes.
Nag. Where is the evidence? It was seized from Srinivas Automobile.
Yes.
Unless you bring evidence on record to show that Srinivas Enterprises was owned by or is the owner, he was in possession, something of that sort, then it might have been seized from there.
Examination and the section 213 stated that the stock in question did not belong to him.
Then,
He was not doing any business.
then,
He was, but
then. Yes. You file a written note, huh?
yes.
You concentrate there. The shop doesn't belong to you from where the seizure has taken place. And the PW1 has not supported the seizure. PW4 has partly supported, but even if the seizure is proved, if it's not seized from your premises, where you own it, because the shop is the named and style is Srinivas Enterprises, and you are Kameshwar not, unless the ownership is established, the liability will not come. Okay, you prepare a small note and give whatever you want to speak. Okay.
But my lord, nothing
Oh,
was
yes, yes.
seized from
Huh?
petition. But my lord, nothing was seized from the conscious possession of the present petitioner. So.
Are you arguing against your client or you want to then?
Sorry.
I'm trying to help you. You are trying to go against you. You read it once again. File a written note.
Yes.
Okay. Somehow I convince in your favor for some time and don't
Yes.
prepare it. Okay, prepare it and keep. And find out some judgments also.
Yes, my lord.
Judgment and do some research work. Okay. Judgment reason. Okay. Sarita Mohana appears and Mona Lisa Manson appears. Okay. Judgment reserve within within a week. Within a week, the written note of submission. Yes. Yes, 85, no?
85.
Who is appearing? 85.
So it's a pattern matter, last opinion, my lord.
Who is appearing? Yes.
Last opinion, my lord, directed.
They are filing. I have my notes sites.
Yes, my lord. Apart, now at this juncture, my lord, the office of R.N. 24, last opinion, my lord, directly to advocate judgments. The appellate court will have power to grant bail in spite of 37 Indian law. And with that, I relied on the NCD versus Raspur Singh.
Yes.
Honorable appellate court that the Gayan appellate court that
You have undergone how much?
4 years, 7 months, 21 days.
4 years,
7 months.
7 months,
In this
21 days. Okay.
the Gayan
Is it reflecting in the judgment? The undergone type.
hearing the
Where does it say substantive sentence of the respondent is 10 years of rigorous imprisonment?
4 years.
The appeal of I could noted that the respondent undergone for the period of
The NCB reform Miller Honorable appellate court, Honorable appellate court held that Miller, though there is a Miller power under section 37, but that is not its place Miller. Did and Miller state formula to detect a well application and that may consider in view of the law.
What does this judgment say?
Detected Miller.
There cannot be a rule of thumb that convict cannot be released on bail pending the appeal against the conviction unless he has undergone half of the substantive sentence. What is the sentence in your case? 10 years. No, what is the sentence? Over the fact that the accused has undergone a substantial part of the substantive sentence, considering the penalty of court is
Appearing for the petition with power of the court was considered by section 37 of the NCA.
Where are you reading?
7
Okay.
which is applicable even at the stage of an appeal. It relies upon the decision of the court in the case of Sati versus State of Maharashtra. There is no dispute about that fact that the appellate court is bound by consideration of section 37 of the NDPS Act while considering the prayers of the grant of bail during the pendency of the case. However, in the fact of the case, an accused has undergone a substantial part of the substantive sentence and considering the pendency of the criminal appeal, this appeal is not likely to be had before the accused undergoes the entire sentence. The appellate court can exercise the power of releasing the accused on bail pending in the appeal. If the relief of bail is denied in such a factual situation only on the grounds.
Okay, what I'll do is I'll seek for a custody certificate and your jail conduct. Okay, and antecedent. Then I'll give you. I'll ask I'll within a rate of
Take instruction regarding.
heard एक ही है 498 of 2024 heard Mr. Patna on the question of suspension of sentence during pendency of appeal. The appeal is the application was heard at length. Mr. Patna has pointed out that in the present case, the provisions of section 55 and 52 capital A of NDPS has not been compliant. He has taken me to the evidence of 1 to 11, 13 and 18. 11, 13 and 18 based on this the state fact. He has also submitted that the trial court, while convicting the petitioner for offence under section 20B to C of TPS, 20BC for the alleged recovery of 37 kgs of contraband ganja, and sentence him to undergo 10 years, 10 years imprisonment. Out of the said sentence, the petitioner has already undergone a substantive part, that is 4 years, 7 months, and 21 days. 21 days. He further submits that although the bar under section 27, 37 for NDPS operates even in the stage of stage of grant of bail in the appellate stage, but the Honorable Supreme Court in the matter of Narcotic Bureau of Control Bureau versus Lakshmi Naran Singh in criminal appeal number reportable judgment reportable 2000 है ना neutral citation is there 2025 INSC 190 so and so versus so and so has held as under para 7 on the basis of the aforementioned judgment and the nature of evidence and the fact that the petitioner has already undergone substantive part of sentence. He submits that the petitioner is entitled to bail pending the pendency of the appeal. Taking into consideration the aforementioned, the State Council is directed to obtain the custody certificate from the jail authority, and so also the jail conduct and criminal investigation of the appellant within a week. Leave the matter. Within a week. 18th. Within a week, Arson? Okay. 9 or 16. 16. Get report. I thought you have declared holiday, High Court holiday. Because you came at 11:30, I thought you so moto declare holiday. Anyway, but please come in time so that in the initial time, when I sit, I want to know the reports. At least the reports I will deal within half an hour. Thereafter, hearing takes place. Yes. Therefore, that time is very crucial. Okay, it's all right.
Sorry, from difficult 279.
I'll urgent, don't worry, there are hearing matters. Don't worry.
But item 15 minute, I'm sorry,
I don't entertain mentioning in between, but I'll accommodate, I'll not pass adverse order. Please don't worry. Yes. Yes.
Sorry, item 21.
21, what happened?
What did you say? First step.
Fresh steps you have to take because service is not complete. Yes. Next. Yes. Full kilometer?
64.
64. Have you got any report in your both of you?
I may be pardoned. In item number 15, I just now got the death certificate. I've forwarded.
Which one? 50?
1 minute.
51.
The
Sole appellant.
Sole
Appellant, 51. Everything. Thank you.
Given the death certificate.
Death certificate. Okay. We will take in report. The report along with the death certificate has been placed on record. As per the report, the sole appellant Jaydev Sahu expired on such and such day. Hence, the appeal stands abated in the absence of any application under section so and so. Yes. Any report, madam? You have any report with you?
Item 59.
Okay.
But not attached. I have submitted yesterday to the office, but did not attach. And 58 is 60.
Do you have any report with you right now? If you have the report, give it.
58.
58. What is the report?
Alive and
Okay. Any of the report?
Then one.
So whatever report you have, please give.
161, huh? 161
61. What is the report?
and allied.
Okay. 61. Give the report. Okay. Anything else?
No.
Mr. Das, you have report?
No.
Your Lordship, I am for 59, item 59.
59, there is no report.
On last occasion, the land council.
I know,
considered
they're
that,
still awaiting the report. Let us see,
It
one
was-
more opportunity is given.
The last chance it was given.
Last chance only, you know how the chances are being exploited. Yes. We'll see next time. Huh? Yes.
Problem.
Yes, hearing.
64.
64.
64.
Are you ready?
Reading.
Yes, 77. 77? Anybody who is ready, you can very well come forward. 77. Yes, sir.
Small note, my lord.
Yes. 77, who is appearing from your side? You are appearing? You. Yes, sir. Tell me.
Small note.
Yes. You have note.
What accused person? The accused person already asked to themselves.
Divakar Amim Parida has been convicted.
Established. 1993 marriage to Malathi. This is Malathi. The basis of Tola Korea marriage. Tola Korea marriage means जब तक वो घर को जाए और वो गरीब लोग तो उससे मैनेज से करें
This is the traditional marriage.
traditional marriage
Okay.
Hindu traditional marriage
Yes.
तापरे बाइबल पर the 12th January 1996 रे माले के एग्जाम से ऐसे छोटी भी अच्छी है को फैक्चर होता है
Yes.
75 98 रे that some undertaking before the police station, but it is the IO that not accepted on the basis of undertaking, not accepted in examination of IO on the FIR. When the FIR, then after the file FIR at the branches of 2000. किंतु 1996 रे गोटे डिस्प्यूट हेतला से डिस्प्यूट को नेकरी माने एफआईआर करछन्ती कि ये बेसिस रे गोटे कोन कॉन्फ्लिक्ट हेतै पारे
Yes.
बट इट इज नॉट एक्सेप्टेड बाय द आईओ एंड ऑन इन्वेस्टिगेशन देयर इज नथिंग डायरेक्ट एविडेंस अगेंस्ट द accused.
Yes.
Not documentary evidence and there is not
Captured.
So for that reason, then after they are completed, undoubtedly completed.
Yes.
They are very old, and they are 498 years later. There, the punishment said abandonment है जैसी, the punishment for husband on her relative subject to the woman cruelty includes the enforcement for the terms that may extend it 3 years and 5. The section defines the cruelty and the conduct that likely to.
Where are you reading?
Page 2.
Okay, 2. Okay, 2. 11. Point number 11.
Point number 11.
Yes.
And cruelty conduct like that, like right from the woman society cause giving injury. There is nothing. Injury किसी नहीं and medical postmortem report रे भी injured नहीं. Report भी है इसी Our harassment for unlawful demand relates to the dowry. Which evidence I will not accept this evidence. You would have FIR purpur history. And other property भी किसी नहीं अभी से जो
You have been acquitted under 304B. You are now convicted for 498A only. What is the sentence?
Only in that sentence He also, with the, one, 1,000 rupees cost, as for.
Fine, fine.
498, four.
Yes. Yes.
Postmortem report, my lord, organic phosphorus poison are coming out into the stomach. They suffer from 36. And the previous 32 women succeeded. Exactly. On the side of accused person, where the brother of accused number will get the informant and the parental uncle PW2 and the PW2 also parental uncle, the sister of the deceased also. Cousin of this is PW5 as two after minor the conducted question. The IO and the SO DFL who was assisted the for investigation.
The earlier police report,
My lord.
that is 17/5/1998, is exhibited.
I thought earlier police report, the report, there is nothing in foundation, man. There is nothing in legal foundation, the police report, there is nothing, a copy of
Sir,
FIR, they are not filed in.
Why don't you appreciate one thing? You have been convicted.
Man.
In an appeal, you have to argue on the basis of the evidence, not on the basis of the story built up by you. This happened, that happened. You show me the evidence.
Man.
See, the trial court has strongly relied upon PW 1 to 5.
Man.
And trial court says that prior to the incident, there was a police complaint against you.
Man.
And a compromise was entered into before the police. And after that settlement, she started staying with you.
Man.
And still the torture continued.
Man.
Again, 2002, this has happened.
Man.
So they are saying that the torture is continuing. It is not incident, isolated incident in 2000 only. It was prior to that also this has happened. Whether that police report after 17/1998, 17/5/1998 is exhibited, proved on record, and if proved through whom, all these things you have to show me.
The IO not accepted the police report.
To show me that portion, read that evidence.
And but the FIR not, the copy of not, and not exhibited in this application, my
ଏମିତି
lord.
କହିଲେ ହବନି ଆପଣଙ୍କୁ
I-
evidence
I-
ପଢିବାକୁ ପଡିବ
I'm studying that.
you just tell me whether do you have the evidence with you. Don't take the chance because 3 years sentence.
My lord,
You have the evidence with you.
my lord,
All the evidence are there with you.
my lord.
Read now PW1. What does PW1 say? Who is PW1? If you want to read, I can give you time. Don't worry. Don't do it hurriedly. Do one thing.
My lord.
Do one thing. Better would be you take the soft copy of the evidence,
Yes.
read it, and then you start. Okay.
I have copy.
Today is Tuesday. I'll hear you on Wednesday, Thursday.
Right.
Okay.
All right.
Partly heard. The counsel for the petitioner, Mr. You are Mr. Sahu, Mr. Prashant Kumar Sahu. Thinks the
I already received the copy, but hard copy I have not collected.
soft copy you take collect the soft copy for further argument on. Yes. Evidence and the note which you have prepared, these are the general statement you have made, but vis-a-vis the evidence also, you have to say something. PW1, what he has said, PW2, like that. And thereafter, whether these earlier FIR is exhibited or not. Why it should be disbelieved? It is not exhibited, not proved on record, that part will not be relied upon. All these things. What is the suggestion you put? What is 313 statement? All these things. Okay. Yes. Yes, Dowry is there. Give a date. Please collect the. This thing.
It will be taken up after lunch.
Huh?
After lunch.
No. He will prepare it. He will prepare it. Because he has not gone through the evidence in particular and find out the links. Whether he is poisoned or not, that is a different story because you have not been found guilty for this. Only the cruelty part, mental and physical cruelty part, that portion you show. Don't you are what I understood is you are not structured your argument. You structured it properly. Don't take that. Yes. 70. 70.
Before starting this case pilot, the case which pilot was used to here on last week pilot, where exhibit A with regards to that exhibit.
Which item?
That the item, the criminal appeal was heard. There was a case of 498 304B.
I have pronounced some judgment today.
No, madam. It was the hardened first only. And my lord was also pleased to direct my learned friend to prepare a note of submission. While preparing the note of submission with regards to exhibit A, in fact, the statement of PW5 has been recorded thrice. 3 times, my lord. And that too, on verification of the records, it seems, my lord, he has stated that I have no objection with regards to the case, and my daughter and my son-in-law, they were fully unwell, everything was fine. I have got no objection, and after that, police has released the dead body and handed over the dead body to the father, PW5, which they cremated. But which statement out of the 3 has been exhibited as exhibit A, that I could not get, my lord, from the record. But by it was specific direction of the court to quote exhibit A, what was the recital in exhibit A.
Yes, that's, that part, yes, I remember now.
So I could not get it.
Shall I list it,
Again, my
Thursday?
lord, to be mentioned or?
Number, give the number, I'll list it. Okay. On mentioning, to be mentioned. To be mentioned. To be mentioned.
My lord, here is the case.
That's a good to, yes.
17.
This is
70.
95, 99.
70.
Yes.
Here, my lord, the appellant has been convicted for the offense under section 326 and has been sentenced to undergo RI for 2 years, fine of rupees 1,000.
2 years. No?
And in default to pay to undergo RI for 6 months for it.
Yes.
This is the case where the occurrence has taken place on January 99, 12/1/99. 1/99. It is alleged by the informant who has been examined as PW1 that while he and his field
PW1 is injured witness.
well, I'm coming to that.
6 months.
PW1 and his field servant PW2, along with one Asaram Mendel, who has not been examined, were plowing the case land named Rugudia Tukuri. The accused came in with a barchi and make protest why they are plowing the land, and accordingly assaulted PW2 by means of barchi, causing bleeding injury. My lord, the defense case is that land belongs to them. They are all related, my lord. The land belongs to them. And on the date of occurrence, while possibly this PW1, 2 and Asara mentally independent witness who has not been examined, they are plowing, his father opposed. After that, my lord, he was assaulted.
The place of occurrence, then PW1, PW2 and Asaram?
Mendel.
Asaram
Mendel, MENDIL.
Asaram. 3 of them were at the spot.
My lord.
At the spot.
PW1 and 2 assaulted the father of the accused by means of a lathi and axe, causing bleeding head injury and other injuries. Father of the accused, he was also medically examined on the very same day, police supervision. And an affair was also lost, which has been exhibited as Exhibit B.
Yes.
But prosecution has come with a case that deliberately present appellant, who is the son of the injured. My father was injured, assaulted him, and they sustained injuries.
Self-inflicted.
No, not self-inflicted, injury.
Injury.
The defense has taken plea of alibi, plea of right of private defense of person. And in that respect, while a specific question has been also been put to PWs 1, 2, and 4, with regards to the circumstances of injuries sustained by
the father, they remain silent. They have not cleared it. What I want to say, my lord, prosecution has not come up the true picture of the case. Because injuries are there. I have sustained on the vital part of my body, but that has not been explained. And you have also sustained.
No, my father.
Not
I protected my father, and in the course, PW2 has sustained only one injury. But that has been.
You were not injured then?
No.
Okay. But you wanted to save your father?
Yes, my lord.
In that process, this injury to PW2.
My lord, we see Exhibit A, the injury sustained by.
And let us see the doctor. Who is the doctor? PW?
9.
PW?
9.
Melbresi.
Yes.
Injury is grievous.
Grievous also. Grievous is like
मरीगले भी किसी वो बापा को मारे.
Yes, PW9 says.
PW9 is at page 55. The stab injury was 2-inch length and 1-inch.
Ratna Khatri is
It was penetrated into the thoracic cavity and it was
No,
caused.
PW2 is Ratna Khatri.
My lord.
PW2, yes.
Ratna Khatri.
80.
Yes. Stab injury.
My lord.
2 centimeters length and 1 penetrated into the thoracic cavity, and it has cause of leakage of air from the wound. During the wound was directed back towards injury was previously to nature and weapon. What was the weapon used?
They say knife, my lord.
Knife.
Well, a peculiarity of the case is, my lord, prosecution has tried to suppress the presence of the father of the accused. But PW1, my lord, may see the evidence of PW1.
Yes.
He has stated the father has come, protested. In villages, my lord, they consider it such a prestige issue. 5 feet, 1 feet be enough for them.
Let us see what he says.
My lord, the
PW1.
Yes, I am the informant in this case. Accused is my nephew, being the son of my younger brother. So and so Tuesday at about 8 a.m. occurrence took place in my land, locally known as so and so. On the aforesaid date at the time, while my laborer, namely Lalit Kheti, Asara Mendli, were plowing my aforesaid land in my presence at that point of time.
Lalit Kheti examined?
Lalit Kheti, my lord,
Period 4.
2.
Period 2, huh?
My lord, his son.
Yes.
My lord, is injured. The father of the accused, this fact emerges at land there. I was altercation in between me and the father of the accused. The father of the accused thereafter left the land and again came to my land with his son. The accused, while he was holding a body, his son was then armed with a spear, Bacha. While the accused entered my land with the Bachi, I told not to assault my laborer. I also further told that if he wants to assault, he could assault me and not my laborer. Despite my request not to assault my laborers, the accused dealt a Barchi blow to the right side chest of my laborer, Lalit Kheti, and
Barchi blow means that is
Barcha.
Borcha.
Okay.
Well, in cross-examination, he has stated that for last 40 years, I am staying at Sambalpur. It is not a fact that in my absence, the father of the accused looked after my land. I got my land plowed by tractor. I have forgotten the name of my laborer who used to plow my land regularly. Santoshini, my niece, also looked after my landed property and got my land plowed occasionally by her husband and so and so. I do not remember the plot and khata number of the case land. It is not a fact that the case land did not belong to my father. It is not a fact that I do not have any document in respect of the case land. It is not a fact that I am not paying rent in respect of the case land. The rent was being paid by me through my brother, the father of the accused, and receipts are now with him. The case land in the last Chakavandi stood recorded in the name of Hemade Pradhan, the principal recorded tenant. I and my brothers are litigating in Chakavandi respect of the case land which with Hebade. I have also appeared in the Chakavandi case and defended my claim over the case land. It is a fact that I have not shown the Bhagapatta Exhibit 4 in Chakavandi camp. It is not a fact that I have not stated before the police that the case land has fallen to my share on the strength of Exhibit 2. It is not a fact that Bhagapatta Exhibit 2 and Lease Deed Exhibit 3 are prepared subsequently for the purpose of this case. It is not a fact that the case stands recorded in the name of the father of the accused. The injured Lalit Kheti is my cousin brother. He has also landed property, though he has no share in the case land. He is my co-sharer in respect of other family property. I was present in the case land along with my wife while my laborers were plying. I do not know if on the date of and time of occurrence, the father of the accused has sustained any injuries, but he has refused that. Sustained any injuries. injuries on his person. I had not seen the father of the accused either at the police station or at the hospital on the date and time of occurrence, but police has registered a case against me and my laborer for alleged assaulting Dinger, the father of the accused. We have also appeared in the court in that case. Accused had told me not to cultivate the case land, stating that the case land belongs to his father, but I raised protest and claimed the case land belongs to me. I have also instructed both the laborers to plow the land despite the protest of the accused and his father. Since I was the owner in possession, my laborers being directed by me continued to plow the case land. Thus there ensued a quarrel in between me, the accused and his father, and thereafter the accused had assaulted my labor with virtue. The accused had once passed the virtue to the right side chest of my laborer, Lalit Rikati.
No, no, this
He
is
says his brother.
after the accused had assaulted my labor with the labor is also injured. Who is the labor?
Lalit Khati, he has said he is the nephew, then says laborer. One person has received injury, Lalit Khati.
But he says that labor is also.
Who is that labor? Nothing.
Labor, PW2 labor.
Labor se Coach Lalit Khati is paying.
How many people got injured? He says that Lalit got injured, no problem.
Lalit Khati.
But at the same time, he says that after the accused had assaulted my labor with Varcha. Thereafter, the accused had once pierced the Varcha to the right side chest of my laborer, Lalit Khetri. Lalit Khetri is a labor.
Lalit Khati he says nephew.
He says labor and what is this? Cousin brother, labor, they are related. What is this?
Labor.
The injured Lalit Khati is my cousin brother. Paragraph 4, first.
But in the cross, he says that he is labor.
Labor. He has also landed property, though he has no share in the case of, he is my co-sharer in respect of other family property. Paragraph 4. Page 38.
And he says that it is not the fact that Lalit and Asaram were not my Holia and that they were not engaged to plug the land.
So he has no share in the case. He is my co-sharer in respect of other family property.
It says it is not a fact that while taking the forcible possession, I and my laborers had assaulted the father of the accused and had caused several injuries on his person. It is not a fact of. Yes, this is the nature of his evidence. Okay.
Valid.
Next.
Similarly, PW2, my let me see. The fact when raised PW1, while we were plowing the land of PW1 on the aforesaid day and time, Dinger, the father of the accused, came to that land and asked me and Asaram not to further plow the case land.
Yes.
This fact enraged PW1 and he told Dinger that he was getting his land plowed through his laborer. Thus, altercation ensued in between PW1 and his brother Dinger. Subsequently, accused also arrived in the case land with that spear and dealt a virtue blow on my right side chest and caused there severe bleeding injury. With the impact of the virtue blow, I fell on the ground holding the virtue, and accused thereafter left the case land with his father.
Informant statement is little shaky, but in so far PW2 is concerned, is very categorical.
Yes.
Right side.
Valid. No, I am not on that right side, left side, or even
and this
why
corroborates with
why
mine.
1 minute if he would have sustained 5 injuries. Because law is very clear, ballot beginning from 68 Supreme Court, ballot 81 Supreme Court, it has been clarified. While exercising the right, it cannot be weighed in golden scale. what sort of right I will use, to what extent I will use, whether my right will cause the death of the person or he will be grievously injured.
The fact that your father was present.
Even apprehension is enough. Court, the Honorable Apex Court has been pleased to observe in many cases, even apprehension is enough to exercise the right.
Now, show me anywhere where anything has come that these people have attacked your father.
No,
Right to private defense, you can see, unless you show
Ballard.
that your father is being attacked.
Yes.
Anybody in the cross
Yes,
examination
that is
anywhere.
validly
Show me
seen.
that portion.
My lord.
Show me
No,
that.
they will not say. The genesis of the prosecution, that it is the duty of the prosecution, my lord, the law is very clear. It is the duty of the prosecution to prove the case beyond all reasonable doubt. When a plea is taken, plea under exceptions, general exceptions like plea of LEV, like plea of right of private defense, or plea of insanity, the burden shifts on the accused.
No, but this that flow from your suggestions.
Yes.
Have you suggested that?
Yes.
Where is that? Suggestion, show me suggestion. PW2 suggestions. Your suggestion 313 and defense evidence. If
Yeah.
at all.
But
313 you have said.
Lord.
Right to private. But have you suggested that?
Yes, my lord, because
I was assaulted, got hold of, there, fallen on the ground, sustained severe bleeding injury.
well, let me see. PW2, sorry, PW2, page 41, last 5-6 lines.
Yes.
It is not a fact
The
that
date and time of the
while taking forcible possession of the case land, we had assaulted Dinger and had caused several injuries on his
Dinger is the father.
father.
Father, okay, Dinger. And
Caused several injuries.
on his person.
It is not a fact that this case has been falsely foisted against the accused to escape the criminal liability of the case filed by the accused and his father. And the injuries sustained, that is murder.
Who has examined Dinger father?
Yes.
Dinger is the father.
And let me see exhibit A, that is there.
Father of accused. Yes. Show me. Who is examining? What was the injury?
I'm showing. They should have given it in the paperwork, but they doesn't. Exhibit A. But let me see.
And PW.
The husband is valid.
PW3 also you have said suggested. Para 3.
Page 26.
Dinger Khatra.
Page 26, exhibit A. Injury report of Dinger Khati.
Page 26.
Page 26. That has been exhibited as exhibit. Must have been exhibited by the IO. And I'm seeing that.
Yes. Exhibit
A.
Exhibit A.
কিন্তু নাহি আগে
Injury report of Dinger Khati. Exhibit A. Yes.
I'm showing it, but I'm showing it must be there.
Exhibit A, just see. Exhibit A. What happened to your FIR? Just
Right,
we
so
find out.
Must have been convicted.
Mhm. Yes.
Well, let me see this.
I got exhibit A. Exhibit A.
26.
But let me see the evidence of IO at page 54, cross examination. It is a fact that the complainant and injured had not stated.
Exhibit A, injury report of injury report.
It is fact that for the occurrence of the same day, at the time, there has also a case registered against the injured informant and one Asaram on the report of the father of the accused of this case, while Exhibit B, while is the formal affair drawn by me under Exhibit B by 1 is the written affair. In the counter case, Dingar Khetti also sent to CSC Bidka for his examination under my requisition, Exhibit A by 2. It is not a fact that the present case has been concocted, fabricating affair and all the factors. My lord, it is there.
You have received, your
My lord,
father
may see- my lord
received
may
4
see-
injuries.
My lord, no, my lord, it's the 4 injuries.
4 injuries.
My lord.
What is the nature of injury?
Lacerated injury, 5 centimeter into 0.5 centimeter scalp over the head, running obliquely, and 1 centimeter in front of the parietal. Lacerated injury, 5 centimeter into 0.5 centimeter skin deep, forearm. Incised wound, 3 centimeter into 0.5 centimeter, that is forearm on his linear single brain, and abrasions of 3 numbers, 5, 6, 7, 8 injuries he has received.
No, 4 injuries is shown.
No, abrasion 3 numbers.
3 numbers.
My
Yes.
lord, then
3, 4 plus 3, 7, 7 injuries.
my lord, 7 injuries.
7 injuries.
And my lord, on the last occasion, I had drawn my lord's attention to the judgment of this honorable court, 92,
Not explaining.
92 volume 5 OCR,
I relied upon and executed.
Krishna Chandra Podha versus State, and 76 Supreme Court 2263. This shows, my lord, they have not come with the case, and squarely, my lord, prosecution, rather, the case of prosecution competes with the.
Then your case is your father has received 7 injuries. You have filed an FIR against them. They are the aggressor, and by way of right to private defense, this has caused.
My lord.
Injury to PW2 has caused because of right to private defense of your father. To save your father, you have done it. That's the whole case. FIR registered.
My lord. This right can be exercised, my lord, for the property of the person, my lord.
And the presence is not disputed. You have put the suggestion to all the witnesses that your father has received injury. Let us see 300. Let us see 313. What defense you have taken?
$313, my lord.
Take it out. 313.
33 page.
30.
33, my lord. 12/19 ତାରିଖ ଦିନ ମୁଇ ଓ ମୋର ବାପା ଡିଙ୍ଗର ଏବଂ ରବୀନ୍ଦ୍ର ମଲ୍ଲିକ ନୃସିଂହଙ୍କୁ ବଡ଼ିଆ ଥାନାରେ ଧାନ ମଡ଼ି ସମୟରେ ଦେଖିଲୁ ଲଳିତ ରେଡ୍ଡି କ୍ଷେତି ଓ ଆଶାରାମ ମିଡିଲି, ଯାହାକି ଆମେ ଗୋଟେ ହଳ କରିବା ଦେଖିଲୁ। ମୋର ବାପା ଏହା ଦେଖି ଆପତ୍ତି କଲେ ଓ ଲଳିତ କ୍ଷେତି ଜବରଦସ୍ତି କରିକି ଏହି ସମୟରେ.
Right, yes, that is there.
That is there.
13.
But let me see, with regards to that, whether the appellant can exercise right, by Honorable Justice.
You have examined the defense witnesses also.
B.K. Behera and Honorable Justice K.P. Mahapatra. The law point.
What was the nature of evidence you laid? Only to right to private defense only?
Yes, that is sufficient. The court says under the law, a person has a right of self-defense, not only to defend his own body, but also the.
That's right. That's right. Your father is being beaten up. You have a right to save him. That's all. That's there is no quarrel. Only to that extent the evidence is there or not. Rightly, you have put suggestion to PW2 as well as PW 3 and 4.
And also I have stated so in my,
And 313 statement. And you have been injured, that is exhibited.
Right.
You have filed an affidavit, FIR,
Right.
which is part of record by.
that has also been exhibited.
That has also been
Exhibit
exhibited.
B, my lord.
And you laid the defense evidence. There are about 9 witnesses you have examined, it looks like.
Like,
Huh? Defense
9.
evidence, how many defense
9.
evidence? Huh?
DW1.
How many witnesses you
9 witnesses, prosecution.
9.
Prosecution, DW likha hai.
1, 57.
So you have examined only one witness, DW1, defense witness. What does he say?
He has only said about the land, ownership of the land. Nobody was there at the spot. So.
Good day. DW1, good day.
No, he only says regarding the land dispute.
Only land.
Land dispute. Yes.
But the fact that evidence, well, specifically question has been put, suggestions have been given, 1 to 4, they denies about the existence of the injury. So they have suppressed that part, that they have assaulted, or PW2 has assaulted my father. Well,
The
language used by the apex court, well, the genesis of the prosecution case is doubtful.
The doctor who has examined your father has not been examined.
No, my lord. Exhibit A has only been proved through
Not examined.
IO.
IO.
My lord.
Let us see the IO statement.
My lord.
PW 9.
9.
No, PW9
8,
doctor.
8.
Doctor.
Yes,
51.
FIR, he does say, what does he say regarding FIR?
Yeah, like other cases, well, he has not gone to that side. He has not also ascertained that affair was lost by Binka PS case number 2 of 99 for 448 307 294 by 30.
Which paragraph it says?
No, that's the affair which has been exhibited.
Oh, no, exhibited through whom?
Exhibited IO ballot has said.
That which paragraph?
Last paragraph, ballot. Paragraph 7.
On the report of the father of the accused of this case.
Page 54.
Exhibit B,
Ballot.
while is the
While
formal FIR
Ballot.
drawn by me. Exhibit B1 over written
B
FIR.
by 1 is the written affair.
Yes. Para
Seven, my lord, page 54.
PW.
This is the recital, my lord. I have the copy.
Yes, Exhibit B.
My lord, this is let me see.
Exhibit B over Exhibit B, huh? Exhibit B. FIR. Exhibit B FIR. This is Exhibit B, huh?
My lord. Father of, lost by father of the appellant, Linga.
ଲଳିତ କ୍ଷେତି ମୋତେ ଟାଙ୍ଗିଆରେ ମୋର ମୁଣ୍ଡରେ ଆଣିଦେଲା।
Corresponding.
ପରେ ଅଗସ୍ତ କ୍ଷେତି ମୋତେ he says that ଏହା ଦେଖି ପରେ ମୋର ପୁତ୍ର ରଘୁନାଥ କ୍ଷେତି ଆସି ମୋତେ ଉଠାଇ ଦେଲା। ସେତିକି ବେଳେ ମୋର ମୁଣ୍ଡରୁ ରକ୍ତଧାର ବାହାରିଥିଲା। ପରେ ମୋର ପୁତ୍ର ମୋତେ ଆଣି ଆପଣଙ୍କ ଠାରେ then the son was trying to save him.
Well,
This is very, can you just translate and give it? Yes, madam, how do you say?
PW2 is not the shareholder of the said.
Right to private defense only concentrated there. See, to substantiate right to private defense, he says that the father of the accused has sustained 7 injuries, which is apparent from Exhibit A, which is proved through the IO at para 7. And thereafter, the father of the accused has also lodged a FIR pertaining to the same incident, where it says that I was attacked by PW1 on my head, which stands corroborated with the Exhibit A. And at that time, my son came and escaped me. The story put forth by defense is under 313 that in order to save the father, the appellant has attacked PW2. So therefore, it is a clear case of right to private defense. How will you deal with it? How will you deal with it?
English could know. These two husbands, it will be helpful.
Judgment.
Both are judgments.
His father was beaten up because there is a land dispute that is apparent on record. They are relative, brother, cousin, and all. There was a dispute, and the father of the appellant was doing bhagochaso. And at that point in time, the PWs and everybody came there,
PW2
and all these things has happened.
not the shareholder of this property.
I've just look at it. I'll just come within 2 minutes. I'll just come. Look at it and tell me. His part is over. Yes, madam. Madam, if defense is taking a plea of right to private defense, the prosecutor has to argue what? Prosecutor has only to argue whether he exceeded or not. That's the only argument you have. You argue on that point, whether right to private defense plea, which has been taken by the defense, is really he has exceeded.
Exceeded. Injury, only see the PW 7.
Hmm.
You examine both the Lalit Khetty and the backer, Dinga,
Who is he?
doctor,
Huh.
PW 7.
7.
Huh.
Yes.
Page 50.
Yes. Whom?
The injury caused by the right chest of the injured Lalit.
1 minute. 1 minute.
Shape of
1 minute.
the-
50. 50, huh? Yes. Yes, tell me.
I examine Lalit Khetty, that son of so and so, that he had sustained a deep penetrating injury on his lower part of his right side and chest overlying 7th and 8th internal costal spaces 1 centimeter lateral to the
This is a single injury, single blow.
injury, but grievous,
But
grievous. And can you see
maybe grievous, maybe whatever.
Huh.
Even murder.
he referred to GSS medical college, but the injury of the accused. Here the doctor not referred the finger cutting. And also the BW9.
Come to para 4 of PW 7.
I also examined the ding.
I also examined
the petty.
so and so.
I examined Dinger Petty had noticed 4 injuries on his person. Exhibit is my report in respect of the injuries found in the person to the Dinger Petty and exhibit 1 with the signature. Dinger Petty had sustained lacerated and inside wounds.
Inside wound on his head
Other parts of the body.
and other part of the body.
Body.
I have mentioned in my report.
VSS medical college, but
Sharp cutting and hard and blunt object. It's not a fact that the report regarding the injuries of Lalit Khatri is false and subjective. That means PW 7 also says that he see 4 injury to the father according to PW 7. Which is 1 injury to the PW 1. Whether can you say it is exceeding?
But can you see the exhibit 9? Deposition PW 9. I found that there was a stab wound on the right side of the chest with the injured Lalit Khetty. The stab injury was a 2 centimeter length and 1 in depth, and it had penetrated.
You are not able to appreciate.
Cavity.
You are not able.
And it has
Listen to
caused
me first.
leakage.
You are reading unnecessary. You are not able to understand. Nobody is doubting that Lalit has received 1 serious injury, which is grievous injury. That's not the point. Point is Lalit has received only 1 injury by the accused. Because the accused has given that 1 blow to save his father. The father received, as per PW 7, 4 injuries. Whereas exhibit A says 7 injuries. If the father is brutally beaten up on head and all, will the son will not step in and to save the father? And he has given 1 blow. If repeated blow would have been given by the accused, then you could have said that he is exceeded the right to private defense. He has given only 1 blow. one blow versus multiple blow. How will you say that he has exceeded? Private defense, you answer that. If you have answer.
Only the PW4.
Hmm?
Wife of the informer. On the aforesaid day and time, I and my husband are getting our aforesaid land, not by our laborers. Asaram mean.
What do you want to say? कुछ भी उठा के पढ़ देने हो जाएगा. You focus your
I
argument.
did not see the ringer, I do not see ringer it at any hospital under going treatment.
So there is no point wasting time. Okay. Judgment reason.
Hmm. 23.
You have relied upon these judgment which are judgment. Mr. Rao, you have relied upon this. Huh? This which judgment?
That 76 Supreme Court I have given, and Honorable Justice B.K. Behra, Honorable Justice K.P. Mahapatra,
76 Supreme Court, which paragraph?
That is paragraph, my lord, 12.
Yes.
My lord has also extensively
Dealt with that. See, right to private defense is the most difficult plea one defense can take. If they fail, then conviction is 100%. But once it is taken, it has to be proved properly. And in this case, it appears to have been proved beyond all doubts. Unless you create a doubt. Yes, 12.
My lord. The omission on the part of the prosecution to explain the injuries on the person of the accused assumes much greater importance where the evidence consists of interested or unequivocal witness, or where the defense gives a version which competes in probability.
You are reading this
Paragraph 12, my lord.
76?
Page 40, my lord, page 401. My lord, after discussion.
401.
My lord,
Yes, which part? Oh, the omission. Yes, omission. Omission on the part of.
my lord.
Yes, omission on the part.
In the instant case when it is held that it must be that the appellant so and so received serious injuries which have not been explained by the prosecution, then it will be difficult for the court to rely on the evidence of PW 1 to 4 and 6 more, particularly when some of the witnesses have lied by stating that they did not see any injuries on the person of the accused. Thus, neither the session judge nor the High Court appears to have given due consideration to this important lacuna or infirmity appearing in the prosecution case. We must hasten to add that as held by this court in so and so, 75 Supreme Court. So, The CC criminals. So there must be cases where the non-explanation of injuries by the prosecution may not affect the prosecution case. This principle would obviously apply to cases where the injuries sustained by the accused persons are minor and superficial, or where the evidence is so clear and cogent, so independent and disinterested, so probable, consistent, so and so. Here, this judgment has also been taken note of in 79 Supreme Court 1010. But here, the injury is a vital part of the body, and prosecution has not made any attempt to explain the same manner.
That this exceeding, it is a death case.
My lord, it's a death case.
Satyanarayan also, Satyanarayan 77, 97.
My lord, it's a death case also.
Exceeding the right to private.
My lord. That can be by the division bench of this court also, it's a 302 case.
This is Behra and this is Mahapatra's.
It's a division bench.
Which paragraph?
That is my lord.
Para 6.
6.
Right of private defense is a very valuable right. It is a social purpose, and this is not a construed narrowly, and it deserves to be fostered within the prescribed limit of so. Anything is coming on record to show that who was the aggressor?
They are the aggressors, my lord. They were plying in the land, in our land. They have assaulted my father first. That is their case. Because if my lord will see the evidence, father opposed. Father came and opposed. We were not plowing. They came and they opposed. I assaulted. No, they were plowing. PW1, PW2, and his laborer who has not been examined. They were plowing the land. PW1 says, I have engaged PW2 and the other person who has not been examined to plow the land. The father of the appellant came there. He opposed. He was assaulted. Son interfered and gave the blow.
That's what the PW1 says.
My lord.
Let us see PW1. The aggressor part has to be seen.
My lord.
Who is the aggressor? Yes.
There are also judgments, my lord, even apprehension is enough.
Yes. You read it, PW1.
My lord.
It says, on the aforesaid date and time, while my laborer, namely Lalit Kheti and Asaram Medley, were plugging my aforesaid land in my presence, at that point of time, the father of the accused entered into my land and unyoked the bullock, and this fact enraged me. This fact enraged me, and there was altercation.
Well, let me see paragraph 5.
No, this is enough.
Enough one.
This fact enraged me. Hey, then he started the aggression starts from
there. Old man was assaulted first.
See, this is only one word.
That speaks a volume.
Me, aggression.
Speaks a volume, yes. Because specific question has been put to him whether he has seen any injury on the father of the accused. He says no. Not at the place of occurrence, not at the police station. they had lost the initial case of 307. We have also exhibit B shows 307. Let me see paragraph 5. I instructed my laborers to plow the land despite the protest. Para 5 minutes. I was present in the case land along with my wife while my laborers were plowing my land on the date and time of occurrence. I do not know if on the date and time of occurrence the father of the accused had sustained any injuries on his person. I had not seen the father of the accused either at the police station or at the hospital on the date and time of occurrence. But police has registered a case against me and my laborers for allegedly assaulting Dingar, the father of the accused. We have also appeared in the court in that case. Accused had told me not to cultivate the case land, stating that
I had also instructed. My both the laborers to plug the land despite the protest of the accused and his father, since I was the owner of owner in possession.
My laborers, being directed by me, continued to plow the case land. Thus, there ensued a quarrel in between me, the accused, and his father, and thereafter the accused assaulted my laborer. But avoided the first part that they had assaulted me. That is the suppression, genesis of the case.
PW2, just see. PW2, this also says PW2 injured is in this in between, say, examination in chief, para 1. The Dingar, the father of the accused, came to that land and asked me and Asaram not to further plug the case land. This fact enraged PW1 and he told the Dingar that he is getting the land plugged through the laborers also. The aggression starts there. Enraged.
I was trying Violet's attention to in the last case while I was arguing that Kustopodo's case. Even a simple injury at the forehead that weighed in the mind of the court. Case of 302.
Yes, okay.
Next item is that he has undergone the sentence and has been acquitted as per their report. 74. 74. That is their report.
10 years
What happened?
10 years conviction. My lord was pleased to call for a report. And the report reveals that after being undergone the sentence, he has been released from the custody in the year 2009. Perhaps after deduction of the
written instruction is taken on record. Where is that written instruction? Yes, what do you say then? Shall I dispose it up for the question of
undergone, already undergone, now undergone.
We forward to matter was partly heard at 9. Following what? The report, the appellant has already undergone the entire sentence awarded to him, and after expiry of his awarded sentence, he has been released from the custody on 1/4/2009. Taking into consideration the aforementioned development which have taken place during the pendency of the appeal, Mr. Dal, who appears for the appellant, submits that he would not press this appeal insofar as the conviction recorded by the trial court for offence under section 404, rather confine his argument to the quantum of sentence.
In
since-
fact, Balladway, instead of saying not pressed, because I have not received any instructions, the letter which I was sent by me, return, answer. So if not,
submit that. Despite
Balladway dispose upon merit.
then I have to write a full judgment. I have to appreciate it. It is appeal.
Yes. Something is to be written ballot because already order gone and no reply. For that reason, perhaps. No,
Then it has to be the appeal. I have to appreciate evidence and I have to
Dismiss.
confirm the conviction. That's the problem.
Not appeal cannot be not pressed. So
Then I'll simply say that he has not received any instruction despite repeated this thing.
or
Yes.
make a mallet.
He has no idea about the well-being of in that view of the matters. I'm not entering into the merits of the
Because the letter written to him, because he must have got instruction where the police people are going. Because some clients are turning up after the police searching.
What was the age of this? 22 years?
47.
47, my lord.
47.
Must be
47.
Helen Hattie, but
So I just record it and appeal on merits dismiss and under the other one. Because I can't dismiss like this. I have to record something.
well, something.
In some paragraph, I will reproduce and say that I don't want to interfere. Okay.
PW45.
I am appealing the conviction and the sentence he has already served out. So just dismiss the appeal. That's all. Yes. Anyone is ready?
I have given reference of 2-3 cases. If you take it up on day after tomorrow,
You can.
498-304.
And in any case, that matter to be mentioned, the one which was
Yes,
judgment
that case,
reserved, to be mentioned.
references given.
Yes. Yes, Mr. Mohan.
When number 75, I was going through the record, Lordship. He was never released on bail, Lordship.
What do you want?
Lordship may call for a report regarding whether he has undergone all the period or else I will argue on merit.
What was the offense?
Lordship 376 2F,
Sentence?
10 years. He was never released on bail. I was going through the records. Lordship.
Mr. Mahathir and counsel for the appellant submits that the appellant has been convicted for offense under section 376 and on that count the appellant has been awarded a sentence of 10 years. 10 years. It appears from the record, according to him, it appears from the record that the appellant was never released on bail. So the appellant might have undergone the entire sentence period. In that view of the matter, he praised that a report may be sought from the prosecution. Accordingly, the prosecution, the respondent state is directed to place a report by next week regarding the period undergone. Period undergone. Next week. If you have already undergone the period, the same way I will dispose it up.
Yes, sir.
Okay.
Okay.
Yes, anybody is there ready? Yes, Mr. Mahanti, are you ready in any matter? Okay. Nobody is there. Okay. Thank you. 2 o'clock.
Item 21, there is a NBW issue against the opposite party in between. Although I was present, so sorry at that time when this matter has. I don't know.
NBW, what happened? NBW?
NBW has been issued against the petitioner in between. Although press notice has been issued and he has not allowed.
Notice and respondent number 5 is not sufficient. What are you asking in this matter?
There is a NBW that I have filed an IA to quash the NBW.
Was the
Quash the NBW, non-bailable warrant against the petitioner. The two NBW against the petitioner for CRLMP 293, for which the petitioner has come to quash this case, the proceedings, and also another NBW for CRLMP 198 by the code below. Just I want to give the certified copy of this.
NBW will be issued. This is an order under 125. If you don't comply, NBW will be issued. How can I stop it?
In the last occasion, in the notice has been already issued.
That's right, but you have to serve. If you don't serve, how can I say it like this?
In the previous another case.
What is the area? What is the area? According to her.
In the CRLMC 5170, Honorable Court has pleased to order to give 30,000 only. But before this order, the petitioner has paid already 45,000, above 15,000.
Where from I'll get these things? Orally, you are saying all these things. Where is the order of the trial court? Asking you to pay the maintenance. Where is that order? 125 order. Show me. Which is that order?
In the please look at a glance at the page number 20. Page annex 2, page number 20.
I have said that 60,000 rupees was then when I passed the order in 2024. 60,000 rupees was the arrears. I say pay 30,000 rupees and keep on paying regular maintenance and go and move application. That also you have not paid. Today you want intervention.
Before that, already we have in this case 45,000 has already been paid.
Oh, I am not here to calculate all this thing in this proceeding. You have to move application, appropriate application.
NBW has already issued against the.
Therefore, you have to go to the court and where is the order of NBW?
NBW I have filed.
Have you paid 30,000 also? No.
Already I have just. I have given, and in that order it is written that out of 60,000 already 30,000 has been paid.
30,000 also you have not paid.
Out of 60,000 already.
No, this is the finding. This is the after the order was which I passed, and the court says that the High Court order is not complied. Therefore, NBW.
Total 60,000. Out of that, we have paid 45,000. Although Honorable Court has ordered us to give.
Where is the NBW order? Where is the NBW order? Where is the NBW?
And in the another 20,000 also paid in the next CRLMP, the 293.
I don't want to go in. These are maintenance petition. I don't want. Area of maintenance is 40,000. You don't pay.
area,
And then the trial court and high court, everybody is engaged for recovery of 40,000 rupees. What is this? I will dispose it of staying the NBW, go and appear and pay the money. Otherwise, I will not enter.
Millard, in the last case, so the CRLMB 198, we have already paid
I will
45,000.
not going to come. If you have paid, you have to satisfy the trial court. I am not here to calculate your money, how much you paid, 40,000, 30,000, I don't know. What is this?
Millard, please, the NBW may be stayed till next part.
What is he asking here? In this proceeding, why this proceeding has come? Allow the prosecution of free. That's all the other options. Who is counsel appearing? Who was the counsel appeared last time when I passed the order?
Millard, in the
You can't pass the ex parte order like this. Who was the counsel when I passed the last order?
Millard, Mr. A. Tripathi.
You serve through the, Mr. Tripathi. And please file it.
Millard, at least
The
NBW.
service on respondent, the opposite party number 1 is not complete. Learned counsel for the petitioner is granted liberty to serve opposite party through opposite party, sole opposite party, yeah, through through her counsel. Through her counsel leaves the matter for the inquiry.
Millard, at least the
That's it,
NBW.
don't waste time.
Millard, NBW may be stayed at least.
No, no.
Till further
No,
next.
no, you said how ex parte order, I don't know what you are saying. How much you paid.
Till next date at least.
No, nothing. Don't waste time. Day after tomorrow, I am listing it. Serve through the counsel who appeared. Then I'll see. Okay. Okay. Yes.
Item 19.
19. 19, huh? Yes. Yes. Yes, sir.
May I please, your lordship?
Yes. Yes.
There are three
It
appellants.
is conviction under 498A,
304B, read with section 34 of the Indian Penal Code.
498A, 304B.
My lord. And under section 4 of the Dowry Provision Act. So for 498A is concerned, 2 years rigorous imprisonment and fine of rupees 2,000.
2 years, huh?
Yeah.
304?
B, 7 years.
Yes.
And so far the DP Act is concerned, no sentence was awarded. though-
Undergone period?
Yeah.
Undergone period?
Undergone period, the Tolakota record କହିଦେବି. I have not examined.
Just check it up, undergone period. That's very relevant info. Do you have, madam? How much? 18? 12, 2004, yes. Sorry, 30? 13, 1, 3.
30.
Bail. Bail, huh? Arrested. And after
21,2007. 21 January 2007. And they released on bail on 5/2/2007.
5 to?
2007.
Okay. Bail, okay. So this is about 2 months something. Okay.
Perhaps that period will not help in this case
because minimum sentence is 7 years, so far 30.
I just wanted to know.
Aye.
Yes. Yes.
Now I am coming to the case in hand, my lord.
Mm.
The appellant number 1 and 2 are the parents of appellant number 3.
No, that's not available. No, that's not available. Yes.
And appellant number 3 is the husband of the deceased. That is the relationship. And the marriage took place on 17/12/2004, my lord.
Suryanarayan Acharya is the husband.
Yeah?
Suryanarayan Acharya.
No, Robin and Acharya.
Robinarayan Acharya is the husband.
Huh.
Suryanarayan Acharya is father-in-law.
Father-in-law and
And
mother-in-law.
Savitri Acharya is
Mother-in-law.
mother. Okay. Yes.
Marriage of the deceased with the appellant Robinarayan took place on 17/12/2004, my lord.
Yes.
Huh? Oh, sorry, I am sorry. Date of occurrence for it. Yes, you are correct.
Okay.
And
13/12/2002.
death occurred on 17/12/2004.
Yes.
That means 2 years after the marriage,
Yes.
the death was occurred. The prosecution allegation is that the
Yes.
law took its motion
Yes.
on the basis of a written report lodged by PW7, who happens to the brother of the deceased, my lord.
Okay.
Inter alia alleging therein that at the time of marriage, the and 1,50,000 and 1 lakh again, 1,50,000 was demanded at the time of marriage. That was complied as per the affair story, and articles were given. Subsequent to the marriage, a motorcycle and cash of rupees 1 lakh was demanded, for which she was subjected to ill treatment and harassment.
Yes.
And ultimately, it is found that the deceased died due to suicidal hanging. So far, the suicidal hanging is concerned, it is not disputed, and died in the house of the in-laws. To that extent, there is no dispute from either side, either prosecution or defense. Now, to substantiate the allegation, as many as 16 witnesses were examined by the prosecution.
Okay.
For better appreciation, I will categorize the witnesses in 3 categories.
Class. Okay.
My lord, PW 3, 4, 7, 11, 12, and 15.
PW 3,
3, 4, 7,
3, 4, 7,
11, 12, and 15.
11, 12, and 15.
Aye.
Yes.
They are the family members of the informant. I am just explaining how they are related.
Okay. Family members. Okay. Next category.
Next category is PW 1, 2, 5, 6, 8, 9, 10.
1,
They are the
2, 5,
6, 8, 9, 10.
8, 9, and 10.
Aye.
Okay.
They are the outsiders.
Independent witness.
Aye. And none of them supported the prosecution case in any manner. Rather, there are some sentences appearing in the cross-examination which goes in favor of the appellant.
The third category.
Aye.
Official witnesses.
First,
Official witnesses. Third category.
third
PW.
category official witness. PW 13, 14, and 16. 16 is the IO. 14 is the postmortem doctor. And 13 is the scientific officer who visited the scene of crime.
Yes.
So in these 3 categories of witnesses, Lord Court below relied upon the evidence of the family members and recorded the conviction. And so far the defense plea is concerned, it is stated that there was no demand of dowry at the time of marriage or subsequent thereof. The deceased was living very happily in the house, and she has a history of suicidal tendency. On that fateful day, the husband appellant and father-in-law, they both were at their service place. Getting the information, they came to the house, took the deceased to the hospital, where the doctor declared dead. They intimated the fact to the in-laws, parents, family of the deceased.
Thereafter, out of emotion, they attacked the appellant's family, took out the small baby who was in the lap of mother-in-law, and thereafter, both the parties went to Shahidnagar police station. There, the Shahidnagar police told that it comes within the jurisdiction of Mohila police station. So both the parties, they went to Mohila police station. At Mohila police station, the affair was lost.
Easy. It's very odd, it looks like. Easy to challenge, yes.
So in this case, your lordship may take note of the affair was marked as Exhibit 1. And so far the defense is concerned, to waive out the burden in terms of section 113B,
13B.
10 witnesses were examined, including the appellant Surjanarayan as one of the witnesses. I will later on analyze the evidence of defense witnesses. First of all, my point before your lordship is that this is a case where prosecution has not properly proved the affair here. Why I am saying so? Your lordship may turn to the evidence of PW 7 with the informant.
PW 7, no? Okay.
Examination in chief,
PW 7.
last paragraph, my lord. Paragraph 5,
Paragraph 5, no?
PW 7, page 114 of the paperwork, my lord.
Yes. Yes, para 5. After arrival of my elder brother.
Second sentence is important for the purpose of my submission. I came to the PS along with him means Lalit Kumar Das. Here Lalit Kumar Das has been examined as PW 11. Your lordship may note that fact. And lodge the affair Exhibit 1.
Yes.
And Exhibit 1 by 1 is my signature. The lordship get it? From this evidence, it appears that he himself scribed the affair and presented before the police. Am I correct, ma'am?
Coming with PW 1. Yes.
Now, your lordship may turn to page 116, paragraph 13. That is in the cross-examination.
Yes. FIR was scribed by my brother-in-law.
My brother-in-law, Lalit. That means PW 11. I am taking a pause. Further, I am bringing my lord's kind attention to the next page, that is page number 117. Erroneously, same paragraph was mentioned, 13 in both these. That's why next page, your lordship, on the middle part of the evidence, there is no endorsement in Exhibit 1, either that it was scribed as per my instruction or that it was scribed by said Lalit.
Where is it?
Para 13, page 117,
Yes,
my lord.
I am on the relevant day, myself and my brother.
Yes, sentence comments on the relevant day.
And
Tari pancholine chhadikri.
ready and said advise submitted a written report. Thus we prepare the written report by exhibit so and so. There is no endorsement in exhibit 1.
Either that
was scribed as per the instruction or that was scribed by Lalit. Okay. Not the factor, yes.
According to him, now the substance of the evidence of PW7 is that the written report was scribed as per his instruction, but there is no endorsement to that effect. Now I will turn to the evidence of PW11, whether he has supported the said factum or not, that is to be examined.
11, okay. Yes. Lalit.
PW11.
Yes. Starts from 137.
Yes, 137, my lord. Your lordship may omit paragraph 1 and 2. In the second page, what he stated, Thereafter, I came to Capital Hospital. Your Lordship, got
Yes,
it?
Capital
One
Hospital,
sentence after.
to know that the deceased died. A fire was lost at Mahila PS by Nihar Ranjan Tripathi, my brother-in-law. I was examined by the IOS also.
Yes. Matter stop there.
Hmm.
He has nowhere stated that it was scribed by him. Am I clear, my lord?
Yes.
Now, your Lordship.
Nihar is PW7.
Aye?
Nihar is
Informant PW7, he said that it was scribed as per my instruction by my brother-in-law PW11.
Yes.
PW11 is silent that he scribed the affair. Now, your Lordship may turn to the evidence of PW16, that is the IO.
Yes. Yes.
Yeah. One minute, my lord. Yes, at page 173, paragraph 19, my lord.
Yes. The
The
complaint.
complainant, Nihar Ranjan Tripathi himself has scribed the affair. The correction made in the affair at page 1 is without having any initial by the maker of the affair.
I have not directed investigation of proceedings also. Yes.
So now but three versions are in the case. So I said from the very beginning that the affair was neither properly proved nor the scribe was exactly examined. Then whom to be believed? Whether you will believe PW7, IO PW16 or PW11. If
Yes.
this being the very beginning of the initiation of the criminal proceeding, if the document is a suspected document, then what will be its effect? I will bring my lord's kind attention to a case clause. That is a case law reported our own High Court. That is a division bench judgment reported in 1991, volume 1 OLR at page 289.
Yes.
Rajkishore Rao and others versus State of Orissa versus Rajkishore Rao. What their lordship said.
Can I get that copy? Bigger one.
One copy is with me.
Yes. What does it say?
They said that in view of these circumstances, it creates a genuine doubt about the truthfulness of the contents and the inception of the criminal proceeding itself. So from the very beginning, it creates doubt. That is the observation of.
But here the case is these two witnesses, 7 and 11, both of them had gone. For
Yes,
the
yes.
purpose of registration of the FIR. Who has scribed is somewhere.
That is the crux. Had the prosecution laid evidence through PW11 that I scribed as per the instruction, matter would have been settled. We can forget what the IO says. Am I clear, my lord? Now three versions are coming for one. One says X wrote the report, X says Y is silent, and Z says that it was scribed by another. Because it was written in the police station itself.
Yes. Which part?
Synopsis number 1, my lord.
Yes.
Appreciation of evidence.
1990.
Witnesses giving inconsistent version regarding the scribe of affair.
Yes. Para?
Paragraph 3, my lord.
Yes. Forwarding statement. Material witnesses to the court. Para 3. I read it. The decisions that analyze the evidence and disbelieved the prosecution case, that is, he found the plain paper appeared to be of the doubtful origin, and it had not been proved as to who scribed it. Who scribed it?
Conclusion that the document becomes doubtful. And the allegation labeled therein is also doubtful.
Yes. What was the offense here in this case?
Offense here in this case,
302.
302.
Yes.
Volume 1.
Volume.
Yes.
Now my second plank of argument before my lord is that
First one. Okay.
the allegation labeled against the appellants in the affair and the evidence of PW7 is diametrically contradict to each other.
FIR, and PW7.
My lord, he is the author of the, he is the informant, that's why I refer his evidence directly.
Contradictory. Yes.
To substantiate my point, I will invite my lord's kind attention to the written report first.
Yes. Which part?
57.
Page 57, 57.
57.
61.
Written report is 61.
May I permitted to read because it is relevant why I am making such a submission that it is different from the evidence.
Yes.
ମୁଁ ସୋ ଖାରବେଳ ଭୁବନେଶ୍ୱର ଜଣାଉଛି କି ଆମ୍ଭର ସାନ ଭଉଣୀ ଶ୍ରୀମତୀ ଜ୍ୟୋତ୍ସ୍ନାମୟୀ ତ୍ରିପାଠୀଙ୍କୁ ଆମ୍ଭେ 2002 ମସିହା ଡିସେମ୍ବର 13 ତାରିଖରେ ସ୍ଥାନୀୟ ୟୁନିଟ୍ 9 ସ୍ଥିତ କ୍ୱାର୍ଟର ନମ୍ବର ସୋରେ ରହୁଥିବା ଶ୍ରୀ ସୂର୍ଯ୍ୟନାରାୟଣ ଆଚାର୍ଯ୍ୟଙ୍କର ବଡ଼ ପୁଅ ଶ୍ରୀ ରବିନାରାୟଣ ଆଚାର୍ଯ୍ୟଙ୍କ ସହିତ ହିନ୍ଦୁ ବୈଦିକ ରୀତିରେ ବିବାହ ଦେଇଥିଲୁ। ଦି ନେକ୍ସଟ ସେଣ୍ଟେନ୍ସ ଇଜ୍ ଇମ୍ପୋର୍ଟାଣ୍ଟ। ଉକ୍ତ ବିବାହ ସମୟରେ ଶ୍ରୀଯୁକ୍ତ ସୂର୍ଯ୍ୟନାରାୟଣ ଆଚାର୍ଯ୍ୟଙ୍କ ପରିବାର ଦାବି ମୁତାବକ ଯୌତୁକ ବାବଦକୁ 1,50,000 ସୁନା ହାର, ସୁନା କାନର, ସୁନା କାଚ, ସୁନା ମୁଦି, ସୁନା ଡେସ୍କ୍ରାଇବ୍ ଲୁଗାପଟା ଏବଂ ଅନ୍ୟାନ୍ୟ ଆଶ୍ରବାସପତ୍ର ଦେଇଥିଲୁ। I am taking a pause, my lord, for better appreciation. The allegation as it labels the cash of rupees 1,50,000 along with the gold ornaments and other articles were given as dowry on the basis of the demand made by the family members of one of the appellant. Now, straightway, for better appreciation, I will turn to the evidence of PW7, what he says.
Yeah, let us read it completely.
ଟିକେ ସିକ୍ୱେନ୍ସ ରହିବନି, ମୁଁ ସେଥିପାଇଁ କହୁଛି।
PW7.
ହଁ, କାରଣ ସେ ପଢିଦେଲେ ତାକୁ ଆମେ ଟିକେ ଜାଣିପାରିବନି what is the difference between the evidence.
Okay, PW7.
ଆଜ୍ଞା, at page 112.
Yes. Cash demand of 150 for the marriage.
Accused, your lordship read two sentences after. Accused Surjanarayana and Savitri are respectively the father-in-law and mother-in-law of Jyotsna. Chaturabhuja Rautray was the mediator of the marriage from both the sides. Why I am uttering that Chaturabhuja, who is the mediator of the family, was not examined in this case. I will explain later on. Because he is the outsider, proper, independent witness to say the factum of demand and giving the dowry.
Okay. Yes.
Next sentence comments, from the side of the bridegroom, there was a cash demand of rupees 1,50,000 for the marriage, and out of that we had paid rupees 80,000 before the marriage. At the time of marriage, the usual ornaments, bed materials, etc. were given by us. Now your lordship may distinguish the difference what he stated.
The demand is 1.50. but
1.5
80
was given at the time of marriage. That was the entire demand amount. Am I clear, my lord? They demanded 1.5,
No,
and
out
that
of
was
it,
given.
ଦେଇଥିଲୁ. Okay.
When it was given at the time of marriage.
Marriage.
Now he make it a
80,000 is demand is 120, 150, 80 was paid.
80 was
But in the
paid.
FIR it is said that 150 was paid. That's
Right.
it.
On the day of Nirband.
Yes.
So far the other demand as described in the affair, that was not demand according to him. Am I clear now? ma'am?
Yes, yes. You
Now again I humbly request your lordship to come to the affair. The sequence of events, what he narrated, whether that was deposed by him during trial or not. ଦୁଇ ଦିନ ପରେ ମୁଁ ଯୋଉ ସେଣ୍ଟେନ୍ସ ଛାଡ଼ିଥିଲି ତା ପର ସେଣ୍ଟେନ୍ସ ପଢୁଛି।
ହଁ 2 ଦିନ।
2 ଦିନ ପରେ ଉକ୍ତ ସୂର୍ଯ୍ୟନାରାୟଣ ଆଚାର୍ଯ୍ୟଙ୍କ ବଡ଼ ଝିଅ ଏବଂ ମଝିଆ ଝିଅ ଆମେ ଦେଇଥିବା ଯୌତୁକ ନିମ୍ନମାନ କହି ଆମ ଭଉଣୀକୁ ଗାଳିମନ୍ଦ କରିବା ଆରମ୍ଭ କରିବାରୁ ମୁଁ ଉପସ୍ଥିତ ଥାଇ ସେମାନଙ୍କୁ ଗୁହାରି କରି ହାତ ଗୋଡ଼ ଧରି ବୁଝାଇଲି ଯେ ନୂଆ ବାହାଘର ବର୍ତ୍ତମାନ ଆପଣମାନେ ଟିକେ ଧୈର୍ଯ୍ୟ ଧରନ୍ତୁ। At this stage I will take a pause. The two Nonandas, sister-in-laws,
They were not examined.
they were not arraigned as accused in this case.
Not examined also.
No, they were not arraigned as accused because allegation is that they told inferior articles were given.
Yes, they were also party to the demand.
Exactly, madam.
Yes. ଯୌତୁକ ଆପଣ ମାନେ yes.
ଏହା କହିବାରୁ ଶ୍ରୀଯୁକ୍ତ ରବିନାରାୟଣ ଆଚାର୍ଯ୍ୟ ରାଗି ଯାଇ କହିଲେ ମୁଁ କିଏ ଝିଅ ମାନଙ୍କର ଭାଇ ମାନଙ୍କ ବାହାଘରରେ ଆମେ କଣ ଦେଇଛୁ
ତୁଳନାରେ
ତମର ଏସବୁ ଜିନିଷ ଗୋଟିଏ ଡ୍ୟାସ୍ ତାର ତ ସିଏ ତ କହିବାକୁ ଚେଷ୍ଟା କରୁଛି ମୋ ଭଉଣୀ ବେଳକୁ ମୁଁ ଭଲ ଜିନିଷ ଦେଇଥିଲି ତମେ ଯୋଉ ଦେଇଥିଲ ଇନଫିରିୟର ଆର୍ଟିକଲ୍ସ ବୋଲି କହୁଛି। ତାପରେ ହେଲା ନେକ୍ସଟ ହଉଛି ଡିମାଣ୍ଡ ଅଫ ଭେହିକିଲ୍ସ। ବାପାକୁ କହି ତୁରନ୍ତ ଏସବୁ ଫଇସଲା କରିବ ଦ୍ୟାଟ୍ ମିନ୍ସ ଇନଫେରିୟର ଆର୍ଟିକଲ୍ସ ଟୁ ବି ରିପ୍ଲେସ୍ଡ। ଗାଡ଼ିଟିଏ ପାଇଁ କ'ଣ ଆମକୁ କହିବାକୁ ପଡ଼ିବ ଏସବୁ ଯଦି ଶ୍ରୀ ସୂର୍ଯ୍ୟନାରାୟଣଙ୍କ ସ୍ତ୍ରୀ ଓ 3 ଝିଅ 3 ଜ୍ୱାଇଁ ଦେଖିଥିଲେ କେହି ସେ ମୋ ଦୁଃଖ ଶୁଣିବା ପରିବର୍ତ୍ତେ ମୋତେ ଯଥେଷ୍ଟ ମାତ୍ରାରେ ଡରାଇବା ଛଳରେ ଗୋଟିଏ ହିରୋ ହୁଣ୍ଡା ସ୍ପ୍ଲେଣ୍ଡର ମୋଟରସାଇକେଲ ଦେବା ପାଇଁ କହିଲେ। I am taking a pause. This subsequent demand of a hero motorcycle was made according to the affair 2 days after the marriage. Your lordship may take note of.
Yes, I understand.
And that was not deposed by PW7 in his evidence. That means he has given a go back to the assertion made in the affair.
Yes.
Thereafter the demand is next page ମୁଁ ପୁରାଟାକୁ ପଢୁନି। Demand was made to bring some cash with vehicle. Next page, page 63 madam. Specific, it is alleged that October ମାସ ପ୍ରଥମ ସପ୍ତାହ 2004 ମସିହାରେ ସେମାନେ ଧକ୍କା ମାରି ଆମ ଭଉଣୀକୁ ଘରୁ ବାହାର କରି ଦେଇ କହିଲେ ଯା ପଳା ତ ବାପା ଭାଇ କହି ମୋଟରସାଇକେଲ ନେଇକରି ଆସିବୁ ଏବଂ ତା ସହିତ 1 ଲକ୍ଷ ଟଙ୍କା ନେଇ ଆସିଲେ ଆମେ ମିଶି ପୋଖରୀ ପଟରେ ଜମି କିଣିବୁ। That means subsequent demand is that a motorcycle along with rupees 1 lakh. And it is stated that at the latter stage the informant paid 30,000 out of the 1 lakh which has been demanded.
30,000 पेमेंट है ठीक है।
Now, your lordship, at this juncture, because that is later on the allegation is formal, they got information, went to that is not material. Now, at this juncture, I would like to invite my lord's kind attention to the evidence of PW7 again.
Yes.
Para 2, my lord,
Yeah.
of exemption chief. Some days after the marriage, the husband and father-in-law of the Jyotsna started subjecting her to torture, including physical assault for non-payment of balance demanded amount. According to affair, there was no balance amount. Am I clear, my lord?
Yes. What
And
is-
here he says that 80,000 was
Because
paid.
in the context of 80,000, he says. balance.
Yes.
Hmm.
And for not giving the demand of motorcycle, here why I am saying the motorcycle matter, from the beginning in para 1 last sentence your lordship may see, the motorcycle theory was incorporated from the very inception. There later on motorcycle was demanded. Para 1 last line,
Yes. Demand of motorcycle.
a motorcycle
Yes.
Besides the aforesaid demand of cash, there was also a demand of a motorcycle from the side of the bridegroom before the marriage. That was not the case of the informant.
Yes.
Thereafter, he has stated,
Further demand of 1 lakh rupees for the purpose of purchasing land to fulfill.
next page, my lord, 113.
Yes.
Sentence comments further. Tinta sentence chhadigiri. Lordship, get it?
Yes. Yes.
Further, Jyotsna told me and my wife that unless the balance demanded cash and motorcycle are
Marked it.
not
Marked it.
given.
I've already marked it.
Again?
I have already marked it. Yes.
So, before whom the disease disclosed? Disclosed before PW7 and wife of informant. She has been examined as PW15. Your lordship may take note of why I am emphasizing her evidence. Just a moment before going further, for better appreciation, let us turn to the evidence of PW15. Whether she corroborated this factum. Very short exemption in chief, my lord. Whenever my deceased sister-in-law comes to para 2, my lord, that is the relevant para, comes to my husband's house, she used to reveal about torture on her by her father-in-law. Deceased Jyotsna Mai died on so and so on 12/12/25 when the deceased came to her parents' house. She revealed before me on being asked that said torture by her father-in-law is still continuing. That means only she make an allegation against the father-in-law for torture, not for the non-fulfillment of dowry or non-compliance of further demand of dowry. Am I clear?
Yes.
What the brother has said, that was not corroborated by this witness.
Yes.
In this context, I will make a further prayer before your lordship to turn to paragraph 4 of the evidence of said witness. PW15, my lord, at page 159.
Yes. Para 5.
Para 4, my lord. The statement which has been given in the examination chief, that was not stated by the witness before the police during examination.
Para 5 also at the time of negotiation of marriage, the accused Ravi wanted.
It is not a fact.
I cannot say. We also.
Para 4, my lord.
Yes.
At page 159.
Hmm.
Your lordship get it?
Yes, yes.
Now, if this fact will be deducted from the examination chief as the development subsequently, and it is a contradiction, then PW 15's evidence has no evidence value to corroborate the prosecution case.
Yes.
And this fact was proved through IO PW 16 at para 24. That was proved.
Yes, 24.
24.
Yes. 179.
179.
Para 24.
At page 179, para 24, my lord.
This is was causing mental torture. Where that after keeping the family? Yes.
So the residue of evidence of PW 15 is marriage was solemnized. She died on such and such date. To that extent, evidence. All other factum which has been alleged, that was not in
Not
her.
corroborating with 7. Not corroborating with 7.
And she also contradicts the what the PW7 alleged, that my sister came and make allegation in presence of my wife.
Let us concentrate on 304 part 2.
304 part 2. 304 part,
Part 2. What is the evidence?
304
Sorry, part 2. 304B.
B.
Huh.
There is no evidence.
Let us see that.
Died due to committing suicide.
Who is the doctor?
Doctor is PW 14.
14.
14.
14, huh? What does doctor says? Yes. Read that. PW doctor.
Now I will come to the other evidence because the court below, while passing the judgment, said that all the family members, witnesses whom I pointed out, starting from the PW 3 to 15, they corroborated each other. My humble submission is there is no application of the mind. The judgment, while writing the judgment, simply he quoted what they stated in the examination chief without analyzing whether each other corroborate to their evidence or their evidence lends corroboration what they allege in the affair. That was not critically examined, which is required to be done. Before going analyzing the other evidence before your lordship, I will bring my lord's kind attention to a case law of our own High Court. This type of cases, how the court will deal with the matter. Because their lordship says that after the death of a daughter or sister, it affects the mental sentiment of a person. Sometimes sentiment or emotion override the reality or real truth. In that case, the court is required to examine the evidence very thoroughly and scrutinize it, which has not been done in this case.
Yes.
In this regard, I would like to invite my lord's kind attention the case law reported in (1994) volume 7 OCR at page 91. Babacharan Barik versus State of Orissa.
Do you have the copy?
No,
How will I read them? Read which paragraph?
After their lordship allowed the appeal at para 9, it is a case on section 304B, my lord.
How big is it? Bigger judgment or what?
Again?
Judgment is a very big judgment.
Judgment delivered.
No, your lordship. You should carry the fund. This is the junior job. The sheet will get photocopy. Then how will I read? How will I coordinate with this? Imagine everything. Citation 2000.
Citation is 1994, volume 7.
OCR
page 91.
Volume 7. OCR
Page
Pa-
91. Baba Charan Barik versus State
Para
of
9.
Para 9 যাই সে জজমেন্টটা হয়ে গেল তারপরে অবজারভেশনটা দিলে
Para
It
10.
was after the conclusion of para 9, their lordship has observed something. This is a guiding principle for the subordinate
Yes,
to
we
follow.
read para 9. Para 10. Yes.
I am just placing that.
Yes.
Before we part with the case, a word of caution is to be given. Courts are called upon to adjudicate the complex question whether in-laws have become outlaws and have directly or indirectly contributed to the snuff out of the life of a woman. Dowry death are results of their disgraceful acts, but the courts have to be careful in shifting the evidence to see whether the accusations are true or are aimed at false implications.
That is the first principle. You have to be careful when the interested witness in these kind of cases have deposed. You have to see very carefully. That's the principle.
So why I am placing it, even if this is the guiding principle laid down by our own High Court, then the trial court has not applied that principle while adjudicating the matter. That is the reason I say that this judgment was not properly written by analyzing the evidence.
Yes.
Now I am coming to the evidence of PW3. PW3 is the one of the brother minor.
Yes.
Rupees 1.5 lakhs. Your lordship, you get it? It was decided that before the marriage we would pay rupees 80,000 besides giving other articles, and balance demanded amount would be paid by us later on phase wise. The aforesaid amount of rupees 80,000 was paid to the said bridegroom at the time of Nirbana. Why I am saying
Demand of 1,50,000 is consistent, but the mode of payments
exactly
is variation from FIR, but PW3 and 7 are consistent there.
I will convince you of why I placed this fact. For better appreciation, I will just turn to page 97
Yes.
of PW3, para 15.
Yes. Yes.
The entire latter part of the evidence, what is stated regarding torture and non-fulfillment, that was a contradiction which has been put to the witness.
Yes.
And that was proved through IO PW16 at para.
Yes.
Para 20 my lord. 20 onwards, confrontations were proved. Now I will take your lordship's kind attention.
Death is poisoning or what?
My lord?
Hanging or poisoning?
No, hanging. Hanging by sari.
And there are injuries on the body.
My lord?
Injuries are also there. in the body.
There are two injuries on person. That has been explained by the doctor.
Was it bolted from inside? Any evidence to that effect?
My lord?
The door was bolted from inside.
Yes, it is said that at the
After I read.
no, 11.
11.
Yeah.
Yes. Partly the 11 was read out.
On 17/12/2024 ଉଠୁ ପଢିଲେ ହବ।
In the para 1, it says that at the time of marriage, the part, apart from all the articles, cash of rupees 80,000 was given.
Yes.
to
At the time of marriage, your lordship may mark the difference. He says at the time of marriage, the other witnesses
Nirbandha time.
nirbandha.
I know, I've seen it.
It is not that twice the money was paid.
Yes.
Thereafter, whether he has any knowledge that the deceased was subjected to ill treatment or not, he has stated at para 2. About 4-5 days prior to the date of occurrence, on Sunday, the accused person demanded dowry, assaulted the deceased.
Yes.
Due to non-fulfillment of demand of dowry, partially or fully, she was subjected to ill treatment. That is not the case of this witness.
When that Nirbandha had taken place, when the marriage.
Nirbandha date, exactly date, 15 days prior to the marriage.
There is no bigger gain. It's all right.
Here, very peculiarly, two persons who are independent persons were present at the time of Nirbandha. They were present at the time of negotiation. That is mediator, one Mohanty Babu. Mohanty Babu happens to be the employer of PW7.
Yes.
It is not known why these two witnesses are withheld and not examined.
Yes.
Para 4 PW11 କହିଛନ୍ତି କିଏ ଥିଲେ ବୋଲି। Chaturabhuja Raut, Dasarathi Mohanty, and others were present.
Yes. Yes. Para 10, 142.
Your Lordship, prior to that,
Para 10, just read para 10. It is not a fact that the cash of rupees 80,000 was not given to the accused person. The date of negotiation, as per the demand.
it is suggested.
This suggestion is there. Whether it was paid in date of negotiation Nirbandha or it was paid at the time of marriage is a contradictions there. Yes.
Your Lordship may
See, these
have a glance
contradictions
to-
are there.
Huh?
These contradictions are there
Huh.
quite clearly. Yes.
Your Lordship may turn to page 141. Sentence comments, it is not a fact. Again, it was confronted to the IO regarding he heard that she was subjected to ill treatment, assault. 4 to 5 days
It is
after.
obvious because he is not part of the family, he is the brother-in-law. He would have heard it only. That's not material. Yes.
Now, the remaining witness is the mother of the deceased and another brother. I have placed the evidence of PW3,
Yes.
15,
See, who are they?
11. Now, your Lordship may turn to evidence of mother.
PW?
PW 12.
Yes. He also says 1,15,000 demanded, 80,000 paid.
What is stated? Other articles were demanded, which is not the case of any of the witnesses. 8 tolas of gold and other articles, including color TV, fridge, to which we had made at the time of marriage. दिया है कोटी मैरेज दिन Now, so far the 1 lakh cash subsequent demand, your Lordship may have a glance to the evidence of this witness. About 6 days prior to her death, the accused persons asked for to bring rupees 60,000.
Yes.
Nowhere she has stated that 1 lakh was demanded. And this is a new story which has been introduced by PW 12.
Yes.
Now your Lordship may turn to paragraph 5 of the said witness. Again, I will say that what he has stated that is contradictory from his previous statement or previous statement. And that was proved by IO by para 23.
Yes. Ready.
So this is the nature of evidence. Now,
which PW 13 scientific officer? Huh? Why scientific officer is examined?
Again?
PW 13 scientific officer.
Huh? Why he visited the spot to examine the scene of crime.
Okay. Okay. Yes.
It is not material.
Yes. I go. Ready. Yes. Which witness now?
Now I will rely a decision of the Hon'Ble Apex Court. They said that if there are independent witnesses to say the factum of demand or giving the dowry, and those who are withheld and not examined, then court cannot record his conviction basing on
These are not thumb rules. These are the first principles. These are not thumb rules. In every facts of the case,
yes, yes.
depends.
Here is a case.
If the nature of evidences are there, its quantity of evidence is not important. Quality of evidence is important.
2 witnesses consistently it is said that the mediator was present. In presence of the mediator.
That's the wisdom of prosecution not to examine Chaturbhuj. Chaturbhuj is not examined. There is no dispute about it. And can you force the prosecution now? You have to examine this, otherwise the entire case goes.
That is
It's
the,
again the quality of evidence which has come on record.
exactly. I place the quality of evidence before your lordship.
Yes.
I
I
brought-
thought that the evidence which because all the witnesses, the first set of witnesses, those witnesses are the family members, and it has been carefully whether family members are implicating or not. If the contradictions are looming large at the record, then their trustworthiness is doubtful. That's the whole gamut of your argument.
Your lordship.
I understood that. And I find out the contradictions also, material contradictions also. Apart from that, what else you have?
Apart from that, let us say close here. Your lordship.
Physical, mental torture and demand of dowry is addressed largely. Let us concentrate on 304B.
Exactly. I am relying on another decision. So far the contradictions I pointed out, affair, evidence and inter-se contradictions, coupled with the, in this regard, I would like to bring a decision of our own High Court, reported 40 OCR.
What is the ratio?
Ratio is like this. Witnesses who have deposed about the dowry torture and ill-treatment in court have not stated to the IO during investigation. From the IO's evidence, it appears that witnesses tried to develop the prosecution case in course of trial by stating things they had not stated during the investigation. Held prosecution not proved the offense on section 304B of the Indian Penal Code.
Highlight and give photocopies. Yes. That's right.
And also their lordship, what said the next sentence? If such evidence of such witnesses is discarded, neither the offense on section 498A or on section 4DP act will consider. So that is the decision. Keeping this,
Yes, particularly because the second set of witnesses, this is not one. There are 1, 2, 3, 4, 5, 6, 7, 8 witnesses. Those who are independent witnesses have not supported the
prosecution case in any manner.
Therefore, the other witnesses, those who are family members, those witnesses has to be carefully looked into.
Exactly.
That's the whole.
Yes. And coupled with that, the independent witnesses who could have thrown light to the truth of the allegation,
They have not been examined.
They were withheld.
Deliberately withheld. That's your case.
So,
particularly Chaturbhuj. Particularly Chaturbhuj, who is the mediator of the case, marriage.
Yes.
He would have been the ideal witness who could have said that whether, because he is the person who has negotiated. In his presence, the money was paid. So he would have been the right witness to be examined.
To be examined.
But the prosecution has not examined, that is their problem. And all other witnesses, independent witnesses, they tried to examine, they have not.
But did not support the prosecution case.
Yes.
Now, another angle of the case I would like to bring my lord's kind attention. The defense witnesses who deposed, their evidence was not properly addressed by the trial court.
Yes.
Because they are the witness from the side of the defense, we cannot skip over their evidence.
What have you said there?
There are different types of sequence which has been deposed by
what was the more or less, what have you said? And
one of the witness I will say that
you need not read it out and tell me what you wanted to bring what through them.
So far
there was no demand.
There is no demand. They were present at the time of Nirvan and there was no demand from the side nor anything was given. This is one aspect. So far the tendency of suicide and advocate was examined as PW3 or DW3, my lord. What happened? One day the DC tried to commit suicide. The advocate was called upon and he counseled. And during discussion, the DC revealed that sometimes he do not understand what to do and he has a tendency from before marriage for commission of the suicide. So this is the evidence. This evidence was not taken into consideration by the Lord trial court because he is an advocate by profession having no link with either family. Only on the ground that after knowing the...
In 313, have you said that? He has a tendency of committing suicide.
Yes, PW3 or DW3.
313 statement.
Yeah, yes, that was stated. Again, I will come to that was elaborately stated by one of the appellant who himself tendered as a witness in this case.
Read it. 39. Question number 39. Do you want to say anything more about the case? The witness says, Bina Jautugare Bivaya Hichi. Read that part.
Sujana Acharya. Bina Jyotiraj 39.
সম্পর্ক ভালো ଥିଲା ଆମେ ଯୌତୁକ ମାଗିଛନ୍ତି ଲାଷ୍ଟ ସେଣ୍ଟେନ୍ସ କହିଛନ୍ତି
No, where have you said that he had a tendency, suicidal tendency, in your 313 statement?
And that is not there in that. That was explained by tendering one of the appellant as a defense witness. She has explained. He has explained.
Yes.
No. And the reason for discarding the evidence of DW3 is that why he has not reported the fact to the police.
You just answer me one thing.
Yeah.
See, the death may be a homicidal death or a suicidal death or accidental death or natural death. The expression used in 304B is unnatural death.
Unnatural.
Whether the unnatural death which is occurring in 304B covers suicidal death also.
Yes. Yes.
Have you found out any judgment? 304B. Whether it is expression is unnatural death. Yes.
ସେ unnatural ଶବ୍ଦ ଲେଖୁନାହାନ୍ତି other than under normal circumstances. The wording legislative.
No, that's right. That's there. But if you can prove from record, it is a case of suicidal death. It is no more an unnatural death. It is suicidal death because she herself have committed. For that, there is a specific offense. 306 is there.
Yes.
So in that case, 304B can you employ by under the aid of 113? That's the question. You answer that.
306, if the offense will be 306, then 113A will operate.
That's right.
And 304B,
because you see, 304B, if you read it, please read it, 304B, where the death of a woman is caused
by any burn or bodily injury or occurs otherwise than
the normal before her death is subjected to cruelty or harassment by harassment or any relative of harassment or any connection with that, the demand of dowry and such death. Why I'm asking this question is, if you have demonstrated from whatever you argued is, there was no torture. If there is no torture, if you can say in the same time you can prove that it is a case of suicidal death, then perhaps 304B will not operate.
306 will attract
yes.
Simpliciter.
Yes,
your lordship, on that point your lordship is right.
That is why I am asking this question.
Yes, your lordship, on that sequence.
If I accept your argument that there is no harassment
or demand of dowry.
That's that
then
part.
It's a case under section 306 as your lordship.
Yes.
306 is a distinct and different of. No charge was framed under that section. That is the lacuna in the.
Then that part we'll see. That part we'll see.
Yes. 306 will attract.
Yes.
outrightly I admit that 3606 will.
That there you have a case. Why don't you concentrate there? Because if I believe your argument, I accept your argument. The harassment part goes. Then she has a suicidal tendency which you brought on record. And there was one witness, it was PW 14, no, PW 13, the brother-in-law. It was suggested also. It was suggested that she has a suicidal tendency. Who is the brother-in-law? That is PW?
DW.
No, the brother-in-law. Brother-in-law is PW. That brother-in-law.
11.
11. There was a suggestion put by you, the last. Yes. Come to 142.
Yes, sir.
Page 142.
Yes, sir.
The suggestion was there. It is not a fact that the deceased Jyotsna had suicidal tendency and that the deceased died committing suicide. And it is not a fact that the instances of in-law so. The suggestion, this suggestion coupled with the DW statement makes out a case of 306 at best. At best. In that situation, what will happen?
Happen as your lordship pointed out, the legal question will be, it comes within the ambit of penal provision section 306 of the Indian Penal Code.
Yes.
Then the distinguished factor is that always for the all safeties of the defense and prosecution, alternative charge should have been made.
And coupled with the fact that, as I asked you, she has died bolting the door from inside. So this is not the case that these people have strangulated or beaten and hanged her like that. She has closed the door and committed suicide. She had a suicidal tendency. It's somewhere the evidence is also coming. In that situation, it would be a pure and simple case of suicide. If the evidence of the family witnesses, insofar as the harassment and torture and everything is believed as per your argument, then 304 is straight away washed out.
Yes.
If 304 be straight away washed out, then 306 remains. And how to treat 306, that is another argument. We'll see.
That is another plank of argument.
So therefore, you show me now that the door was bolted. Who has said that door was bolted from inside? Then we can arrive at a conclusion that she is a case of suicide right there. Show me that.
That point I will examine.
Show me that part. That is the most important part.
I do understand what your lordship possessed me to answer, whether the door was bolted inside.
Bolted from inside and it was committed, it was broke open and
it
she
was
was
broken
removed.
and the dead body was recovered.
Where is that part of our evidence? It is not, I have just glanced through, but I am not getting anywhere. Maybe the hostile witnesses might have said somewhere in the cross-examination.
Hostile witnesses.
Merely hostile doesn't mean that we will just throw them. Some part of the evidence which is corroborating.
I will examine that part of the evidence.
There we have to concentrate. Prepare a note. I'll hear you. I'll hear you. I'll hear you. Not there. Let us see. Let us see. Let us see how things are moving.
I will prepare a short note.
Yes.
Referring which I have referred during course of my argument, and also the supporting case laws for your lordship's consideration. And the point which your lordship posed to me,
yes,
I will again go through the evidence and point out under which circumstance the deceased was recovered, whether it was inside the room bolted or not, and who are the witnesses to that.
First of all, let us ascertain whether it is a homicidal death or suicidal death or accidental death or what kind of death it is. Thereafter, we will examine 304B, how will you apply in the absence of any evidence for torture and harassment. In the absence. In the presence of those evidence, how we will treat? In the absence, how will you treat? And you could successfully show me the contradictions Contradiction, material contradiction.
Contradiction to make it a case from the ambit of 304B. The other question your lordship asked, that is another.
So in that way, we have to examine.
Aye.
Yes, we'll. So, huh? No, we'll have to have a hearing. See, I will have a hearing. It's a parted. Put it after 1 week or so. Prepare, they will prepare, na? Note. Come with the.
1 week. 1 week.
After 1 week. And prepare the note and come with all judgments, photocopy of the judgments. Yes.
Judgments photocopy I will supply.
Yeah. Madam, you also, now you understood how things are moving now. Yes. Yes, and
ଆଉ ଗୋଟେ ମ୍ୟାଟର ଥିଲା ଆମ 72 ସେଟା ଗୋଟେ ତ ଟିକେ ଦରକାର ସାହାଯ୍ୟ ଯଦି ନବାକୁ ପଡିବ
soft copy you take soft. Yes.
ମିଳୁନି ସେଟା ଆମ ପାଖରେ
72 soft copy too. ठीक है.
बहुत दिन सिक्योर लगे
ये अच्छा ये
बहुत दिन सिक्योर लगे
67 ରହିଲେ ନାହିଁ ପିଇଦବ କିଛି
67.
May I please?
Yes, Marana, you have to also prepare. Marana, you have to prepare a written note also.
Yes, my.
Because this is a bit critical. You have to examine that. Huh? You have to show from the evidence, not that the clinching material. I'll just record clinching material and convey.
That is my lordship.
Though the defense counsel tried to discard the evidence.
Yes.
We'll see that he could successfully show me some contradiction.
Yes.
To what the contradiction works in his favor, that we will see examine. But the question which I asked, that has to be appropriately answered. If it is a suicidal case, and the contradiction pointed out by him is believed to be true, whether in the absence of a specific charge being framed, can you convict him on 306 or not? That's the question.
306.
36.
Yes, alternative charge is there.
Then it is a simple 306.
Yeah.
Because 306, why 306? Because there is a suggestion to the witness. Coupled with that, there is a evidence of DW which is that it is a case of suicidal death. Thereafter, if it is bolted from inside, it is a case of suicidal death.
That part of evidence is missing, first of all. And assuming that is a case of suicide also, the Supreme Court says that comes under the 304B. 2015 Supreme Court, they have already held it. There is no categorization between the
Because it is coming under the unnatural death.
Yes, sir.
Unnatural death. Because once unnatural death, whether it is accidental or suicidal, whatever, if it is coupled, lead to the harassment, lead to such death,
Yes.
then 304, that's there, no problem. But if I believe his argument to be correct, if I discard those part of the evidence, harassment part of evidence,
Yes.
then what remains? It will be 306 only.
Unless the prosecution, that part is over, that there is no torture or there is no doubt.
Then that's what I'm saying. In both the aspect you have to look into. Yes, madam.
Yeah, please, your lordship. Here, my lord, appellant 1 already expired. That appeal already abated.
There are many appellants. How many appellants?
2 appellants.
Yes. Yes.
Here, my lord, may I please? The appellants, along with 7 other, face trial in ST case number 59 of 4 of 1995 in the Court of Additional Session Judge, Jajpur, and they have been convicted under Section 436 IPC, and when sentenced to undergo RI for 2 years.
Hmm.
Here, my lord, the prosecution story is that the appellant number 2 and 1 accused Subodh showed some objectionable gesture at the wife of the nephew of the informant, and on being protested, accused Subodh and appellant number 2, they set fire to the kitchen of the informant. This is all about the prosecution story. Here, prosecution has examined 8 witnesses, out of which
PW 1, 2, and 3, they are said to be eyewitnesses. Shall I come to the PW 1, 2, and 3?
Yes.
PW 1 is the Kamala Behera is the informant. She has stated that appellant number 1 had asked the other accused person to set fire to their house. And again, she has stated that appellant number 2 asked appellant number 1 to set fire. And who set fire?
Who set fire?
Appellant number 2 asked appellant number 1 to set fire. Appellant number 1 set fire.
Appellant number 1 who is died.
Appellant number 1 is
One is dead.
dead already.
Yes.
My submission is on appellant number 2.
Yes.
And in her cross-examination, she has stated that her husband had filed a title suit against Rusi and others. These Rusi and others accused persons and appellant number 1 and 2, they belong to one family. She has stated that due to this civil suit issued, this offense already this has happened. Then we come to PW2. PW2 is Rajnikant Behera. He has stated that while he was studying in his house, on hearing Hulla, he came to the spot, and then appellant number 1 and 2 asked accused Subodh to set fire.
Third person.
Third person. Here, my lord, we will come to that point. Here, my lord, accused Subodh and other accused person, they already acquitted. This Subodh already acquitted, my lord. He said appellant number 1, 2 said Subodh to set fire, and Subodh set fire. Then we'll come to PW3. PW3 is Vichitranand Behera, is the son of Khageshwar Behera. My lord, Khageshwar Behera, whose house was burnt. He has stated that he was...
He has also stated that the accused Gorang and Madan told the accused Subodh
that
to set fire
yes,
on the house
PW1
and
and
gave a matchbox to him. Subodh set fire.
Yes, my lord. That is appellant number 1 and 2, Gaurang and...
PW 1 and 5.
1 minute, I'll hear you.
I'll come to that point, my lord.
Yes.
Then on hearing Hulla, he came to the spot and found all the accused persons armed with thenga. And appellant number 1 and 2 told accused Subodh to set fire. And Subodh set fire. He gave matchbox to Subodh and Subodh set fire. Then we'll come to PW4, my lord. PW4 is Abhiram Jena, is the post-occurrence witness, who has stated that he found, when he came to the spot, he found that cow shed of Khageshwar was burning. So he is the post-occurrence witness, my lord.
Cow shed of Khageshwar.
Khageshwar, whose house was burnt. Then we'll come to PW5.
The house is born or cow shed is born?
He showed that cow shed was burning, not house.
1 minute. The other witnesses said what? House. House. Okay. Yes.
Then we'll come to PW5, my lord. PW5 is the Khageshwar Behera. He has stated that he had been...
Whose house was burned?
Whose house was burnt. He has stated that he had been to the field, and from there he saw that in the village, smoke in the village. He saw that smoke in the village. And thereafter there was Hulla. And he came and found that his house was burning. When he came, he found that his house was burning.
He also says that, read his statement. He says, then the accused Madan and Subodh told to set the house on fire.
Yes.
Then the accused Subodh and Madan set the house on fire. My kitchen, consisting of 2 rooms.
I'm coming.
Yes.
Then he came to know from his wife and his daughter-in-law.
Okay.
Wife is PW1. PW5 whose house was burnt, that is PW5, and PW1 is the wife of PW5. One is. So he came to know from his wife and daughter-in-law
Yes.
that appellant number 2 and accused Subodh peeped into the house. My lord, this here the prosecution story has changed. Subodh peeped into the house on being protested. Appellant number 2 and accused Subodh set fire
Yes.
on this house. Here, my lord, appellant number then we'll come to PW6, my lord. Bhattakrishna Jena is the chance witness who has stated that he had been to Alipur for medicine, and while returning from, he heard hulla and stones were pelted by the accused persons to the house of Khageshwar. That is PW5.
Madan Behra told Subodh Behra to set the fire.
Yes, my lord.
Subodh Behra set the house fire.
Yes, my lord.
Yes.
He said that appellant number 2 told accused Subodh Behra to set fire on to the house of Khageshwar.
Yes.
Then we'll come to PW7, my lord. Krishna Chandra Raut is the second IO, and PW8 is the first IO, my lord.
Yes.
So here, my lord, defense plea was one of simple denial. Shall I come to the findings, my lord?
Yes. Go as per your.
First point, my lord. Here, the learned trial court has disbelieved PW3 and 5. My lord, kindly have a glance of judgment of para 6.
3 and 5 disbelieve, huh?
Yes, ma'am.
Yes. And that's
Para 6. May I read?
yes. Learned counsel for the accused.
Learned counsel for the accused persons has given suggestion to these witnesses that they have not made such statement before the IO, but it is evident from the statement of the IO at paragraph 3 and 4 that in fact they have made such statement before him. The other witnesses PW3 and 5 state that in their presence the house was set fire by accused Subodh being asked by accused Madan and Gaurang. But in fact, it is evident from the statement of the IO that this material statement has been made before the IO in their previous statement under section 161 CRPC, this being the subtractus of the prosecution case. To prove a case of arson, the omission to make such statement amounts to vital contradiction striking at the roof of the prosecution case. Thus, the statement of PW3 and 5 that they are witnesses to the occurrence is not credible, but it is evident from their evidence that they are post-occurrence witnesses and found the house was burnt. So also is the statement of PW 4 and 6. They found the roof of the house was partly burnt. Then we'll come to, my lord. Here, the learned trial court has partly disbelieved PW1. 3, 5.
Completely disbelieved.
Completely disbelieved. Then we'll come to PW1. Here, the learned court has partially disbelieved PW1. While believing PW1 that she had not made any statement on accused Subodh involved in setting fire to the house, while belonging that PW1, 2 were consistent regarding involvement of appellant number 1 and 2.
How the Subodh has been acquitted?
Subodh, my lord, already acquitted.
How? What is the reasoning? Because all witnesses have said Subodh has done it.
All witnesses are acquitted.
How? But how? What is the reasoning given by the trial court to acquit Subodh?
A trial court, my lord, it is completely denial, my lord. It's different story, my lord. One says, somewhere says that appellant number 2 and appellant number 1 misbehaved the daughter-in-law. And here they said when he peeped into his house, all this occurrence happened. So two different stories. So PW1 is completely partially disbelieved, my lord. Here. Kindly have a glance on para 7,
7. Okay.
Yes,
Read it.
page 4
Hmm.
of the judgment.
Yes. It is evident from the statement of the witnesses that the roof of
It is evident from the statement of the witnesses that roof of the dwelling house and cowshed of PW 1 and 5 has been burnt. PW 1 and 2 make statement that accused Madan and Gaurang set fire the house. PW 2 entangles accused Subodh besides the above two accused persons in setting the house on fire. Both
But
the
both the witnesses have
both the witnesses have entangled and made positive statements against accused Madan and Gaurang about setting fire. As PW1 doesn't make statement against accused Subodh, his involvement in setting fire of the house is said to have not been proved beyond doubt.
Oh.
Then, my lord, para 8. At the stake of reputation, the ocular witnesses make consistent, emphatic and unassailed statements that accused Madan and Gaurang had set fire to the house.
Who are you? You are Madan.
Appellant number 2.
What is it? Madan.
Madan.
Yes, madam. What do you say? I understood it now. Yes.
PW 1 and 5
Hmm.
categorically stated the name of the accused.
It's all right, but they have said also Subodh. Subodh set the fire. PW4 says,
PW
except PW1, everybody has said. Subodh has done it. The Subodh has been acquitted. See the reasoning in para 7. Para 7 of the judgment. What kind of reasoning is this? If this reasoning is to be believed, then the Madan also goes. There is nothing to labor hard in this. 3 witnesses are there, you can read straight away. Read it, obviously you have to read it.
I have made a small notes.
No,
Can I-
no. Yes, yes. Read it, madam.
It is evident from the statement of the witness that the roof of the dwelling house and the cow shed of PW 1 and 5 had been burned. PW 1 and 2 make statement that accused Madan and Gauranga set fire.
So that's 7. You are reading. I have read it also. Come to PW1. What PW1 says? Third line, fourth line. My putra was newly married. At that time, Subodh and Madan made obscene gesture to my putra bahu. Then my putra bahu complained before me, and regarding that. So those 2 accused persons abused her in the obscene words. At that time, myself and my putra bahu were present in the house. No male member were present in the house. The accused person threatened at the previous occasion so and so and set fire. This is, he says about Subodh and Madan. PW1 also says Subodh and Madan set fire. Now come to PW2. PW2 also in the similar fashion he says, Subodh, Gaurang told Subodh, Madan and Gaurang told Subodh to set the house of Khogeshwar on fire. PW2 says same thing. PW3 says same thing. 4 also says same thing. But the trial court with the reasoning as per para 7 acquit Subodh. What do you say? Shall I record that you are not opposing for acquittal? Yes, Mr. Mohanty, yeah. Would you like to say anything? What gone through the 2 minutes it takes. Why don't you read it? Or you kept the mind somewhere else. Yeah, 3 witnesses are there, you can't read.
No, 436.
Only 3 witnesses. और evidence कर दो. UPR evidence करो. Yes.
Two and five.
Why it is always one-sided? Only this side argues, that side no. Nobody argues anything. From your side, nobody argues anything. Every time this happens, very. Come to PW3. PW3. Yes, PW3. Next, second line. Hi. Hearing the Ullah, I came to my house. At that time, I found all the accused present there, armed with Thenga, etc. At that time, accused Gorang and Madan. Gorang died. For Madan, this appeal is. Told accused Subodh to set fire to the house and gave the matchbox to him. Then Subodh set fire. Okay?
That's it.
And this is what PW3 says. Come to PW1. PW1. PW1 also says the same thing. Just see. Fourth line. At that time, Subodh and Madan made obscene gesture. So my Putra Bahu. Then Putra Bahu complained. At that time, myself and Putra Bahu was present. No male member was present. The accused persons, these accused persons addressing to Subodh and Madan. Accused persons threatened in the previous occasion and to our and set fire, but they did not done this earlier so and so. Thereafter you see. Then the accused Madan asked to set fire Gorang, and the Gorang set fire so and so, so and so. Subodh role is there. Okay. Next, come to page PW2. PW2, third, fourth line. Then Madan and Gorang told Subodh to set fire the house of Khageshwar. Okay? And next, come to 3, I have already read. Come to 4, para 12. 4 is an independent witness, post-occurrence witness. He says the cow shed of Khageshwar has been burned, not the house. The implication is if this witness is believed, it will be a case of 435, not 436. Keep this aside for the time being. Now come to 5. What 5 says? 5 is the person, Khageshwar, whose house was burned. He says that I got information from my wife and daughter-in-law, that Madan and Subodh Behra peeped into the house, and when they protested, the Madan and Subodh told this to set the fire. Madan and Subodh role is coming there. Subodh and Madan has done it. Okay, this is the nature of evidence. And everybody has taken Subodh name along with Madan and Gorang, and with little variation. Para 7 of the judgment, if you see, this is the reasoning, and on the basis of the reasoning given in para 7, Subodh has been acquitted by not believing the evidence of PW1 to 5. Therefore, Madan is also entitled to benefit of doubt. You know. File written submission.
Obliged.
What is your name, madam?
Sartika Das.
Yes.
Item 78, your lordship on last occasion already heard this matter and
Hmm?
your lordship directed to produce a judgment in the similar light. This is the identical judgment to my case. Relying upon non-compliance of section 50, my lord, how the Honorable Apex Court has acquitted, my lord.
Section 50 of NDPS.
Yes, my lord.
What does it say?
Item 78.
78.
Relying upon the constitutional bench, my lord, this Honorable Apex Court has passed section 50.
But it should burn out from the record by way of
Yes,
evidence.
my lord, identical to my case, my lord, this petitioner case, my lord. Section 50 has not been complied. I have marked the relevant portion.
Top रख दियो. बोल दो. I am tired of being not heard by from the other side.
Sorry, my lord.
Because I am doing both the job.
Yes, ma'am.
Prosecutor's job as well as the court's job. That's the problem. Yeah, double job. Yes. Yes. Sorry, which item?
71 and 80.
What are the offences? 71, huh? Have you prepared a small note?
My lords, in 82 I have prepared, my lords.
Okay. This also you prepare, I'll hear it.
My lords.
You would have highlight, ऊपर टिक लगा दो. Left over you highlight कर दो. 71, 80.
82.
71, 82 and you are saying?
78.
78. ये तीनटा रख दो.
My lords, 71 my lords may pay on the next week.
Okay, 1 week.
82 my lords I will argue.
82 and
78.
70. Okay, thank you.